We'll call this meeting of the Judiciary, the final meeting of our interim committee, to order. Go ahead and will you call the roll, please, LSO?
Senator Cooper. Senator French. Senator Kolb. Senator Cost. Representative Crago. Representative Larson.
What did you say?
Representative Larson.
I'm way ahead of myself. Excused.
Representative Oakley.
Here.
Representative Provenza.
Here.
Representative Washut.
Here.
Representative Rodriguez Williams.
Here.
Representative Yen.
Here.
Representative Swanser. Chairman Nethercott. Chairman Olson.
Here, here.
Quorum present, Mr. Chairman.
All right, thank you. Ladies and gentlemen, as I said, this is the last meeting of our interim. We'll have a one-day meeting, of course, and tomorrow is Veterans Day, so we will not be meeting. But we truncated the agenda to get through one day. So everyone, just my plea to you, committee members, is to stay on point so that we can finish at a reasonable time today and that we can finish our work within just this one day. Madam Co-Chairman, do you have any opening remarks? No?
I do not.
Okay, very good. Let's get to work. First item of business is trespass. Mr. Fuller, we have a bill draft 23 LSO 0108. Mr. Hopkinson. Go ahead and introduce this bill to us.
Thank you, Mr. Chairman. David Hopkinson with the Legislative Service Office. Looking at 23 LSO 108, working draft 0.6. The committee did consider this bill at its last meeting and ultimately took no action then, but continued it to this meeting. The version that the committee is looking at is the same as it was presented at the last meeting, with the exception of the staff comment. That staff comment was designed kind of to incorporate some options that had been discussed, some options that were sent to me as far as potential amendments to address the potential concern that a person returning from a hunt wouldn't be included in this prohibition. And so what the bill draft does, as in the Game and Fish Trespass statute, just adds on page 2, line 2, that no person shall enter upon or travel through the private property of another person to hunt, fish, collect, etc. And then clarifies on lines 7 through 9 that the purpose that travel through requires physically touching or driving on the surface of the property. The staff comment includes a couple of options for amendments. Again, that's entirely up to the discretion of the committee. But the first option there would simply add or return across on line 2 so that it would read, no person shall enter upon, travel through, or return across the private property. And then option B on line 2 of page 2, line 4, after trap, it would insert or return therefrom, so that it would read that no person shall enter upon, travel through the private property to hunt, fish, collect antlers, or trap, or return therefrom without the permission of the owner. If the committee were to go with option A, one additional, it may make sense to add or return across on line 8 of page 2, so that it would read, for purposes of this subsection, travel through or return across, just to clarify that returning across would also require touching or driving on the surface of the property. And with that, the bill draft would be effective July 1st, 2023, and I would stand for any questions.
Committee, do you have questions for LSO on this bill? No? All right, thank you, Mr. Hopkinson.
Mr. Co-Chairman,
Yes.
point of order. I'm hearing from members of the public watching online that they can't hear us.
Well, Rep. Larson, Rep. Rodriguez Williams, can you hear us?
But they're not on.
Mr. Chairman, yes, I can hear you.
Okay, so we're just not, is there some type of problem with our YouTube feed?
Let's just
Okay.
make sure to speak loudly into the microphone.
All right, sorry, go ahead.
All right. Good morning, Madam Chair, Mr. Co-Chairman Olson, members of the committee, good morning. It's good to be here with you again today. My name is Rick King. I'm the Wildlife Division Chief and Chief Game Warden for the Wyoming Game and Fish Department. When I had the opportunity to visit with you at your last meeting, you made two asks or requests of me. One was to bring somebody intelligent and articulate with me that can represent the chiefs and sheriffs. And so I have Mr. Byron Odekoven here today. I didn't actually bring him here. I just made sure he had an invitation. And you also asked that I would bring forth an example or two of scenarios that may help illustrate why this legislation is in front of you today. So I'll get into those examples, but I think just as a little refresher, or to back up a little bit, I think that the genesis of this bill is really from some frustration that some of you all and others have heard from landowners, in that there are trespassing scenarios that occur that really seem like they should be able to be handled by our game and fish wardens when they're out performing their conservation law enforcement efforts. And some of those trespass activities result in an actual boot print, tire track, horse print, snow machine track on deeded private property, and that was the result of hunting, fishing, or trapping activity. I think that the intent of this bill is just to clarify that those trespass scenarios that are out there really should fall within the Game and Fish Title 23 trespass. And some clarification is needed, and I'll highlight one real world example and then give you one hypothetical example to where I think this is applicable. So for one real world example, I'll leave out the names and folks involved, but just summarize the events. So in 2021, we had a hunting scenario develop where several folks were hunting together. There were 4 people in a party hunting with multiple ATVs. They were hunting in a place that has, like much of Wyoming, very mixed land ownership, where there's BLM lands, private lands, and it's all interconnected and mixed together. During the course of the hunt, this party observed some elk, made an attempt to go harvest those elk, and several elk were actually killed and reduced to possession. But during the course of the day, several of those folks drove across private property multiple times. In one case, an individual did shoot on private property and kill an elk on private property. That individual is charged with trespassing to hunt, fish, or trap, and that conviction stood in court. One member of the party was cited for trespassing under Title 23, but the court found that individual not guilty because they had not actually harvested an animal. The court was not clear that there had been hunting activity, an intent to hunt on private property, even though it was very clear that they had crossed private property during the course of their hunt multiple times. In that case, some of our conversations with folks involved in that case referred back to an attorney general's opinion that really clarified or spoke to the fact that in order for a person to be found guilty under 23.3 305B, a person has to, without permission, enter upon private property of another with the intent to hunt, fish, or trap on that private property. And in the case of the individual who didn't actually harvest an elk on private property, the court found that individual not guilty, just the act of driving, even though it was associated with it in a hunt, didn't produce a guilty conviction. I think there's quite a few scenarios like that that occur. I'll just give you a hypothetical example. A person may, using GPS technology, legally access and stay on private property or other deeded property that they have permission to hunt on. They may harvest an animal, but then rather than taking the long route back that they came in on, they may decide to take a shortcut across private property that they don't have permission on to return home. In those cases, there's been some question as to whether that would clearly fall under Title 23. And I believe the intent of this legislation is to clarify that should be covered. It should be something that can be resolved by our game and fish wardens when they're out working. So just in summary, I believe the intent of this legislation is to clarify what activity should be included in Title 23 trespass to hunt, fish, and trap, and clarify that our game and fish warden should resolve those issues rather than passing those on to somebody else or not addressing them. I think, while I don't think that this draft bill language is perfect, I do think it's a good step towards resolving the issue and helping to resolve some of the frustration that occurs at multiple levels, whether that's in the courtroom by a judge or whether that's our officers in the field or a county attorney, or probably most importantly, a landowner who has a legitimate trespass concern that needs to be resolved. So with that, I'll stand for any questions that you might have.
Chairman Washut.
Thank you, Mr. Chairman. Just a quick scenario. Pickup truck driving across private land, game warden observes them. How will that game warden know the intent of that individual just by seeing them on the deeded land? I don't know that it's going to be obvious whether they're going fishing or hunting or collecting sheds or whether they're going to go take photographs. So would the game warden in that scenario have authority, reasonable suspicion to stop that truck and then determine what the intent is of the individuals inside that truck? Or would they simply have to allow that truck to continue on the trespass and until they saw some evidence that they were on their way to hunt or fish?
Mr. King.
Yeah, Madam Chairman, Mr. Co-Chairman, Representative Washut, I think that's a good question, and that question of intent is difficult. And so I think in every scenario where a game warden observes what they believe to be a trespass situation, they do have to make sure that they're observing what would be considered hunting, fishing, trapping, or antler collection activity under Title 23. And I think if a game warden in that scenario saw somebody, oftentimes our game wardens know the landowners in the area that they're working. They're intimately familiar with the landowners and who may or may not have permission. And if they see somebody that doesn't appear like they belong there, I think in many cases they observe the activity until they felt like they had enough reasonable suspicion to inquire further as to what they were up to and whether they had permission.
Representative Zwanitzer.
So when we're discussing, in your scenario, you talked about when people were leaving. Does that mean when they're driving off the animal, or let's say I spent all day and I had to hike a couple miles and I got an elk. I got to pack that thing out. And it's half a mile, quarter mile through private property. It's 3 miles around the other way. Have we cited people for trespass after the fact? And we're getting to the amendment here. I mean, as a private property owner who has elk, I don't want anybody hunting my land, but if they get it someone else's and they need to hike back through mine, I think I'm okay with that. But where does that distinction lie in your mind? I don't want them crossing to hunt, but I don't mind them packing it out across me if that's easier for someone, because I know how horrible that is.
Madam Chair, Mr. Co-Chair, Representative Zwanitzer, I think that's a scenario that occurs often, and I think for many landowners, there's an expectation that if anybody's actually crossing their private property in any way, shape, or form, they want to have permission. And in many cases, our wardens have issued citations for just that scenario. A person harvested an animal, but in the continuance of that hunting activity, crossed deeded private property without express written permission. And while there are some landowners that would be okay with that, many are not, and they would like to have the ability for our wardens to address that scenario.
Yeah, you bet,
So
Representative.
in that kind of a situation, would you check with the landowner first and just say, hey, we're not really sure how you feel, this guy was across your land, we know it's your land, do you want us to cite him or not? Do you ask the landowner that before issuing a citation in most cases?
Mr. King?
Yeah, Madam Chair, Mr. Co-Chairman, Representative Zwanitzer, absolutely. The landowners need to be fully on board. It'd be a pretty rare scenario where we would write a citation without knowing that the landowner was on board with charging a person. We have to do our due diligence and make sure that that person doesn't actually have permission and that the landowner doesn't want that person to be on that property.
Committee, other questions for Mr. King? All right, any other thoughts, following conclusions?
Madam Chair, Mr. Co-Chairman, I don't have any other comments for you at this time, but I'll certainly be happy to address any other questions that may come up.
Okay, that's possible to happen, so thanks.
Thank you.
Appreciate that. Oh, see? There you go.
So it's an opinion question, Mr. Chairman. And it's really, at some point when we have a lot of out-of-state hunters, people who aren't familiar and they kind of have an idea that we have checkerboards of lands, is there a point where you think we're going too far and people are going to be, I don't trust Wyoming not to do something weird and cite me, and I just don't even want to come and try to figure out this mess and hunt because it's a gotcha kind of thing. Do you have any complaints now from out-of-staters on that our laws are too, I wouldn't say complex, but too difficult to ensure that they don't cross into private land or that we cite people more than we should at other states? I just want to make sure we have that balance where we're not necessarily discouraging people from hunting at all with if we have any kind of gotcha laws.
Mr. King?
Yeah, Madam Chair, Mr. Co-Chairman, Representative Zwanitzer, I think a couple of thoughts come to mind. So under Title 23, Title 23 is a strict liability statute in that it is the hunter's responsibility to know if they're on private property or not and to ensure that they have express permission to be there. I think that is very straightforward and nearly all hunters, whether they're resident or non-resident, understand that is their responsibility. And I think there's a lot of technologies that are available today to ensure that's very doable for a person to meet that strict obligation. I think that in terms of the draft bill that's proposed today, I don't see this as being increasingly cumbersome for a resident or a non-resident hunter. I don't believe that it creates any more of a gotcha burden.
Now, any other questions for Game and Fish? No? All right, appreciate you sticking around. Mr. Odekoven? Welcome.
Thank you, Mr. Chairman. Byron Odekoven, the Executive Director for the Wyoming Association of Sheriffs and Chiefs of Police. Thank you for allowing me to address the bill. On one hand, we could open up a discussion, and we just about started to do that, on trespass generally and issues with trespass across the board as the committee's weighed different options before. But I think it's important for us to stick to this bill and what this is intended to speak to. It doesn't solve all the issues of all the rest of the trespass, whether it's in Game and Fish or in Title VI. The bill more explicitly states the current expectation. As a rancher, putting on my rancher hat, I want to know who's on my property. I want to grant those people permission or deny them in each and every instance. I don't want to find somebody out there that I don't know, going where I didn't allow them to go, or in the middle of something I just assumed they weren't in the middle of. So this bill helps with that from the standpoint that you have to have permission to travel through, and as you discuss the amendments, or to return from. Because Game and Fish statute, unlike Title VI, talks about intent. Intent to go hunting, collecting antlers, fishing, etc., as opposed to Title VI is merely being there. So with the intent, we also have to have that additional language to ensure that they're going to and coming from is covered within the bill. So I would suggest that we do need to cover or adopt one or the other of the two options, whichever you are prone to do as you wordsmith the best placement for that. Thinking in mind, we've kind of talked about the abstract a little bit. Let me throw out the abstract slightly. So your neighbor down the street has decided to have a backyard barbecue. Is it okay, because it's a rather large barbecue, everybody parked a block away? But if they cut through your backyard, they can get right out to where they know their car is. So it was okay to go around the block to get to the barbecue, but now that I've been to the barbecue, I'd like to cut through your backyard to get to my car, because after all, I know my car is parked right in front of your house. I would offer no. General and custom practice, you don't get to troop through people's backyards. Well, from a rancher's perspective, my backyard just happens to be a little larger than that. And I would like to know who's trooping through my backyard and doing whatever. So I think from the sheriff's and chief's perspective, having clarity in the bill is important. It provides that because, as I mentioned, the intent provision for the Game and Fish, this clearly spells out the intent to return or traverse across as well. So I think it's an important piece. It doesn't address everything associated with trespass, but it addresses this specific point rather clearly and doesn't muddy up some of the other issues that are before the court or before the legislature in the future. Mr. Chairman.
Questions for Mr. Odekoven, Vice Chairman Washut?
Thank you, Mr. Chairman. Mr. Odekoven, do you agree with Mr. King's assessment that the officer in the field is going to have reasonable suspicion pertaining to that intent before they're allowed to stop that vehicle traveling across the land? Because a deputy sheriff would have the authority to stop that truck knowing that it wasn't the landowner and didn't have permission. But the game warden is going to have intent, going to have to know where that pickup's going and for what purpose. Do you agree that they need to have that understanding of intent before they'd have authority to stop that truck?
Mr. Odekoven?
Mr. Chairman, I would agree that they would have to have that reasonable suspicion in order to proceed. You're innocent till proven guilty. So the same would do in your generally accepted conduct. You're going about your business lawfully until we have reasonable suspicion to investigate whether it's an unlawful act. In this particular case, since we are talking an intent statute, yes, they would have to have the reasonable suspicion. You're correct that a deputy, on the other hand, looking at a Title VI scenario on permission has a slightly less or slightly different standard. But the Game and Fish, I would agree, reasonable suspicion standard would apply.
Representative Oakley and then Senator.
Thank you, Mr. Chair. I guess just kind of weighing into that a little bit. It doesn't have to do with the statute per se, but when we're discussing most that I'm aware of, most Game and Fish contacts are what you'd call a consensual contact. They haven't made a traffic stop per se. They're not seized at all. So if you're making a consensual contact, actually, you don't have to have that reasonable suspicion. Anybody can go up. I can go up to anybody's truck and visit with them. So can Game and Fish, that's just kind of important in this, because actually to ascertain if they go up and just ask the person questions and they answer and they're not seized in any way, they don't have to have that. They don't have a burden at that point. Just something for clarification, which is kind of different with in practice how it happens with Game and Fish versus law enforcement. A lot of law enforcement.
Yeah, I think that is really helpful, Representative Oakley. Mr. Otokoven, wouldn't you agree?
Thank you, Mr. Chairman. Yes, I would. Consensual discussion. I like the way you put that. That's very on point, that consensual discussion. I'm mindful that we would counsel officers to merely go up and ask people, can I help you find where you want to go? Well, I'm going over here. Well, do you have permission to go over there? Pretty soon you're asking and answering those kinds of questions to determine where we are. So I like the way that was stated, Mr. Chairman.
Great. Any additional questions?
Mr. Chairman,
Oh, I'm sorry. Senator Cooper, yes.
thank you, Mr. Chairman. Mr. Otokoven, as I read this bill, I see this as a tool for the game and fish to utilize in the field, so they don't have to, they can make that, address that violation without having to sit 2 or 3 hours to wait on a sheriff to show up to do that work. Would you say that's a fair assessment? Is this just a preservation, continuation of the tool to allow them to do their job in the field without the assistance of the sheriff's office?
Mr. Otokoven?
Mr. Chairman, in simple terms, yes. It's one more tool in the toolbox to deal with the issue of trespassing, going and coming, given as we've talked about, the intent portion of a game and fish statute.
Okay. All right. We'll note Senator French, you joined us quite a little bit ago in this conversation. Welcome, Senator French. All right, Mr. Otokoven, thank you. Emily, can we let Mr. Barron in? Welcome, Mr. Barron.
Hello, Mr. Chairman.
The floor is yours.
Thank you. My name is Joe Barron. I'm a county attorney in Crook County, Wyoming. And I'm speaking on behalf of myself. The association, the Wyoming Prosecutors Association, didn't reach a consensus on this language and the proposed bill here. So anyway, what I want to speak to is that I'm generally in favor of this bill. I think it actually takes care of an issue that exists out in the field. The game wardens have to end up calling the sheriff to help them out on. And just as an example, most of these matters do not occur in the presence of a game warden. They just don't happen. What happens is that the private landowners will call the game warden and say, hey, somebody's been over here. And then they call up, and then one of the game wardens has to drive up and figure out what's going on with everything. And then the sheriff's deputy might go up as well. And in our county, we have a lot of private land and a lot of small acreages. And so this happens quite often. Even though hunters are becoming way more sophisticated with their various technologies to know where they're at, some of this is actually dropped, in my opinion, but they, through Onyx and the different Avenzas, different mapping programs, they know pretty much where they're at most of the time. Game and Fish sells things on their sites that have these mapping things as well. At least they used to, because I've seen them brought in court, which clearly say check with local landowners and conditions. One of the things that I would suggest, and I submitted a suggestion list there, is that you add the term on line 3 to insert the term take wildlife. Just because both of those words are defined in the Game and Fish Code, and the actual wording of this statute, hunt, fish, collect antlers or horns or trap, actually limit trespassing in these particular, this entire statute. And so The other thing that I run across is, and it's not really for this statute, I don't think you're going to fix it in this statute, is that the term hunt has no definition. And in the game and fish code, and I clearly like the return across language that the staff brought in on that. But I would just stand for any questions if anybody has any questions on these things.
Questions for Mr. Barron? All right, as always, thank you for your testimony, Mr. Barron.
Thank you.
Back to the room. Ms. King, were you going to testify?
Thank you, Mr. Chairman and members of the committee. I'm here today representing backcountry hunters and anglers, and we just wanted to speak to some of the hunter perspective on this statute. When this bill was originally brought in the last session, I think there were a lot of questions about the intent of the law, and frankly, what the effects would be without kind of clarifying what travel through might mean. From our perspective, and from the perspective of our members, I think with the added definition of travel through requiring physically touching or driving on the surface of the private property, we support the bill. I think one of the realities that we are living in 2022 is that we are living in a state where, more folks are coming in, more folks are buying property, and more folks are hunting. And I think we are seeing in the field, to some extent, some decrease in confrontations between private property owners and hunters. But the reality is, our hunting statutes have not been updated in quite some time. And some of the ways that we find those confrontations between hunters and private landowners is when there is a lack of clarity in the law. So the original bill, without the definition, we thought actually created more ambiguity in the law and potentially would have been quite a problem. But I think with the addition of that definition of traveling through, it provides both for the hunter and for the landowner clarity in what it means to engage in hunting trespass, so that there aren't those gotcha moments. Frankly, we actually see this as potentially decreasing the number of gotcha moments that hunters may have while they're in the field. So with that, I think there are, a lot of other issues that we need to address in our hunting statutes, frankly, and I think that we can do that in the upcoming session. We see this bill as sort of step one in that process, and we support the bill. We'd like to see it moving forward. Happy to answer any questions.
Questions for Ms. King? All right, thank you for your testimony. Mr. Shaw? No? Oh, he's on Zoom? Oh,
Yes, Mr. Chairman, can you hear me?
yep, sorry, I thought you were in the room. Now,
Yes, sir.
the virtual room.
Mr. Chairman, generally, I represent Mountain Pursuit, hunting nonprofit, and I'm from Hoback. Generally in favor of this bill. We agree that this needs to be addressed, this issue, to protect landowners. And we think that bad behavior by hunters is bad for hunting and the future of hunting. Our concern with this bill is that in the future, it may be used to prohibit or fight corner crossing and or float fishing. As I read the bill, it seems like the language in the bill would address that, requiring the surface of the property to be touched. But I'm not an attorney, and I don't understand or know the legal jujitsu that might happen in the future. And so what we'd request is that corner crossing and float fishing be addressed specifically in the bill, just to make it clear that that is not the intent of this act to address corner crossing or float fishing in any way. As I understand it, if there is some concern or interpretation of a bill in the future legislation, the court will always try to interpret what the intent of the legislature was, and that type of language would make this clear. Again, that this act is not the intent of this act to address in any way corner crossing or float fishing. And I'll stand for any questions.
Okay, questions for Mr. Shaw? All right, we appreciate your testimony. Thank you. Do I have anyone else in the virtual world? Oh, that's right. Okay.
Are you sure? Are you sure?
All right. let's go ahead and bring Mr. Novotny in. Well, he's not, I don't think he's appearing as Commissioner Novotny.
Good morning, Mr. Chairman and members of the committee. Can you hear me?
Nope. Yeah, we can hear you, Mr. Novotny. Go ahead.
All right. Well, thank you. I do apologize that I'm not there in person. Obviously, with Wyoming's weather, it can get a little interesting. I'm here this morning speaking on behalf of the Wyoming Outfitters and Guides Association. We want to just again reiterate our strong support for this legislation. We appreciate the work of Senator Crego with his initial bill. And I've already promoted him to a senator, but he's still a representative. But Representative Crego's.
Mr. Novotny is an upgrade or a downgrade. We'll leave that up to the individual to decide, but we'll keep him in the House for now.
I think that's a good idea. He's a valuable member there. And I'm not biased on that at all. But again, we supported the initial concept that did not move last session. We supported this from its inception and the work that's been done to clarify some provisions. We want to reiterate that we'd like to see this remaining from a discussion of corner crossing. That's an issue that's going to have to be settled by the federal courts, most likely. And we would ask that you just move this forward with an affirmative vote from this committee as a committee bill so that this can move into the session. Thank you, Mr. Chair. I'd stand for any questions.
Questions for Mr. Novotny? Nope. All right. We appreciate you zooming in with us. Mr. Litt.
Thank you, Mr. Chair. My name is Guy Litt, and I'm a member of Backcountry Hunters and Anglers. And I'm coming here today to just present a story of, I had the privilege of growing up on private property and hunting and fishing and trapping on my parents' and grandparents' lands. And I understand the feelings that, even though I'm an avid public lands hunter now, I understand the feelings of trespass that private landowners are faced with. And just want to say that I support this legislation, and thanks for all your effort in clarifying it.
All right. Any questions for Mr. Litt? I appreciate you taking the time out of your day to testify before this committee. Thank you.
Thanks.
Any other testimony on this bill? Yes.
Oops. Thank you, Mr. Chair, Madam Chairman. My name is Luke Weddle. I'm also with Backcountry Hunters and Anglers. I'm a member, and I wanted to come in and give a little bit extra perspective from the hunter. And I know whenever we discuss trespass law that we think about the benefits for the landowner and also for the game wardens trying to prosecute anyone that breaks those laws. But there's also some benefits to hunters in general. The first being that these clear lines that we draw help to distinguish hunters from another group that I would consider poachers. And we like to be differentiated from them because they kind of just make us look bad in general. And whenever there's these clear lines, there's also less conflict between landowners and public land hunters. And for those reasons, I do support Representative Crego's bill and appreciate your time.
Questions for Mr. Weddle? All right, we appreciate your testimony. Thank you. Any other testimony on this bill? Any other testimony on this bill? Nothing in the virtual world? Okay, then I will close public comment on 23 LSO 0108. Committee, what is your pleasure? Moved by Senator Cost and seconded by Senator Cooper. Amendments on this bill? Representative Crego.
Thank you, Mr. Chairman. So to start with, and we might do these in a couple parts, but I'd like to propose that option A that LSO has prepared for us. And so that would be on page 2, line 2, deleting or inserting a comma, and after through, insert the words or return across.
Okay. So
And
second
then-
on that amendment?
And then,
Oh, you want to do more?
yes.
Okay, go ahead.
And then the second part of that would be on line 8, after the words travel through, also insert the words or return across with quotes around return across.
Okay. Yeah. Is seconded by Vice Chairman Washit. Any discussion on that amendment? Question on the amendment. All those in favor signify by saying aye. Aye. And those in the virtual world, raise your hands. Good job. All those opposed? Same sign. All right, that amendment's carried. Any other amendments? Yes, Representative Craigo. Maybe.
So, Mr. Chairman.
Yeah.
Can I ask Mr. King one quick question? Can we,
Is the question quick or the response quick?
both, I think.
Okay.
Oh, you're on your own, counsel?
What?
Mr. King, this is wholly unorthodox to reopen public comment, but I think I'll allow it.
Thank you, Mr. Chairman. So, Mr. King, we heard Mr. Barron request the amendment to the language of the current statute to include the words take wildlife either before or after the word hunt. How is that going to affect the bill, and will that be negative or positive in your opinion?
Mr. King.
Madam Co-Chair, Mr. Co-Chair, Representative Craigo, I think that recommendation is a good idea. Take is defined in Title 23, hunt is not. I think that would be a positive addition to the bill.
Thank you, Mr. Chairman. So I would move that we add the words take wildlife to line 3 of the bill.
Seconded by Representative Oakley. Any discussion on this amendment? Representative Zwanitzer?
Yes, Mr. Chairman.
Sounds
That's a
friendly.
perfect spot.
Okay. Discussion, yes. Representative Oakley?
Thank you, Mr. Chair. I just thought, we did discuss this last time, and so I'm just gonna, without take it, it is kind of like we're reinventing the wheel and leaving some things out. So take is defined, it says means hunt, pursue, catch, capture, shoot, fish, sign, trap, kill, or possess, or attempt to hunt, pursue, catch, capture, shoot, fish, sign, I think that's the right word, trap, kill, or possess. So I think it hits a lot of what we're trying to get, and it's already defined. I guess I had a quick question for Mr. Fuller, because when we discussed it before, it seemed like, I don't know, it seemed like you had an opinion on it. Is there something that we legally need to discuss as far as take?
Mr. Fuller is shaking his head, but
Yeah,
he has something.
Mr. Chairman, Representative Oakley, no opinion. My recollection is I think I just referenced the same definition you read.
Okay. Any other discussion on this amendment? Ready to vote on the amendment? All those in favor, raise your hand in the Zoom world and say aye here. Aye. Any opposed, same sign. Okay. Oh. You're a little delayed there, Representative Larson. Was that an aye or nope? Was that an aye or a no? Oh, you're just saying hello. All right, that amendment has passed. Any other amendments? Discussion on the bill? Representative Larson?
Yes, Mr. Chairman. I would like to put an amendment on page 1, line 11. I would like to delete enclosed, like Mr. Barron had
suggested. I do not think that, I have property that isn't necessarily fenced, and I would like this statute to be, work.
Is there a second on that amendment?
You might.
Time out. Oh. Mr. Fuller,
So,
can we amend this title?
yeah.
Well, it's not the title issue, it's that I'm not sure that the concern.
And Mr. Chairman, Representative Larson, there is a separate provision in that section that deals with enclosed lands, firing a rifle on enclosed lands. So I think the reference to enclosed may be appropriate, but I think generally the changes to the section title would be made kind of on the back end as a bill is processed.
Yeah. Co-Chairman, another comment?
Mr. Co-Chairman, thank you. I think the concern that Representative Larson is addressing through his motion is to ensure that the law is not only applicable to enclosed private property, but is also applicable to unfenced private property. A valid concern, however, I don't think is a concern in this bill draft because of the reference to enclosed property in the title, but I don't have the full statute in front of me to read it in paramateria to understand whether or not that is a relevant concern or not, but I sense that it is. And so this concern may cause a drafting error later or may resolve an issue that doesn't currently substantively exist.
Mr. Fuller?
And Mr. Chairman, Chairman Nethercott, for purposes of that title, we would review that and make any changes accordingly when the bill is finalized.
Okay. Now, was there a
Mr. Chairman,
Or yes, Representative.
I'll
Larson.
withdraw my amendment.
Okay. Any other amendments or discussion on this bill? Representative Yin?
Mr. Chairman, thank you. So maybe just a thought on the process, assuming this is, we're voting on sponsorship as a judiciary bill, would this probably likely go through judiciary during the session?
Yes.
Yes. It will be our bill.
So Representative Yan, Mr. Co-Chairman, it will be a joint judiciary sponsored bill, of course, where leadership chooses to assign the bill and which committee to handle it would be up to leadership. But as you know, historically, it would be customary for the sponsored committee to receive the bill draft.
Would you rather send it to labor or?
No, Mr. Chairman. I mean, my only thought is whether this should be open for a wider discussion with TRW folks. But neither here nor there. We can do whatever we want come session, or rather leadership can. And so just a thought on what consideration needs to happen with regards to trespass, since this is trespass focused on hunting.
Okay. All right, that's a really good point. Any other discussion on this bill? All right, Emily, will you do a roll call vote on 23 LSO 0108?
Senator Cooper. Aye. Senator French.
Senator French?
Senator French, your time to shine. You look like he's an aye, I believe. He's raising his hand.
I'm an aye.
Senator Kolb.
Excused?
Senator Cost. Aye. Representative Grego.
Aye.
Representative Larson.
Aye.
Representative Oakley.
Aye.
Representative Provenza.
Aye.
Representative Rodriguez Williams.
Aye.
Representative Washut.
Aye.
Representative Yin.
No.
Representative Zwanitzer.
Aye.
Co-Chairman Nethercott.
Aye.
Chairman Olson.
Aye.
That passes.
All right. I have a feeling if this bill comes to our committee, I have a feeling I know who will be floor managing all the way through the House. All right, we are definitely ahead of schedule, which is a good thing.
So glad we started early.
Can move over to our financial exploitation topic, 45 minutes early if we've got everyone here. I see Mr. Laycock. Oh, you know what? We can take our break now. That'd be a great idea.
We can take multiple breaks if we want.
Yep, let's go ahead and take a 10-minute break and we'll make sure that we get everyone rounded up.
We're adults.
Yep. We are live and we are back, committee. Thank you for the extra few minutes. Just making sure we have given enough time to make sure those who want to be here for the next topic, because we're about a half hour ahead of schedule, which is a great thing. We want to make sure everybody who planned to be here for financial exploitation is in fact here. And we have Ms. Hanson, who is you're going to introduce the bill draft 22 LSO 0279 to us.
Mr. Chairman, members of the committee, Talise Hanson, LSO. I am presenting Bill Draft 23 LSO 279 on financial exploitation of vulnerable adults. This bill draft is a resurrect of the engrossed version of 2022 Senate File 76, but it also includes the Wyoming Bankers Association and Senator Case's proposed amendments. The bill draft creates statutes 13.1701 through 13.1706. 13.1701 starts on page 2 and provides a definitions section. Subsection A3 provides a definition of exploitation. The staff comment on page 3 highlights that the committee may wish to consider whether the definition of exploitation is necessary, as the term exploitation does not appear separately in the bill draft. Page 4 of the bill draft provides a definition of financial institution, which includes broker-dealers and investment advisors. The staff comment highlights that the committee may wish to consider whether special purpose depository institutions created under 13.12.101 should be included in the definition of financial institution for purposes of this article. The bottom of page 4 adds a definition of qualified person, which means any agent, investment advisor, representative, or person who serves in a supervisory, compliance, or legal capacity for a financial institution. Page 5 includes section 13.1702 on reporting financial exploitation of vulnerable adults. Subsection A requires a qualified person to notify the financial institution of suspected financial exploitation of a vulnerable adult. The staff comment highlights that the committee may wish to consider that Senate File 76 required an employee of a financial institution to report suspected financial exploitation, and the proposed change would only require a qualified person, which may narrow who is required to report. Subsection B provides that a financial institution must submit a report to the Department of Family Services and provides a timeline for submitting that report. Subsection C provides that the financial institution is not required to make an additional report. Subsection D allows the financial institutions to adopt internal policies and procedures for making these notifications and for submitting the report. Subsection E allows the financial institution to report suspected financial exploitation of vulnerable adults to any appropriate state or federal agency, including law enforcement. Page 8 starts with 13.1703, which allows the financial institution to notify a third party reasonably associated with the vulnerable adult of the suspected financial exploitation, unless the financial institution suspects that third party of financial exploitation. Page 8 also includes 13.1704, which deals with temporary holds on the transactions. Subsection A allows the financial institution to place a hold on any transaction that involves an account of the vulnerable adult. Subsection B provides that the hold shall not exceed 10 business days after the date the hold is placed. Subsection C allows the financial institution to extend the hold, and subsection D allows the financial institutions to adopt internal policies and procedures. Page 10 provides for 13.1705, which provides immunity to the qualified person and financial institution from any civil or criminal liability. The staff comment on page 11 highlights that the committee may wish to consider whether there should be an express exception to immunity if a person commits perjury or another related offense during the judicial proceeding. The staff comment also notes that subsection A of this section provides immunity unless the qualified person or financial institution acted in bad faith or with a malicious purpose. The committee may wish to consider including language that does not provide immunity if the qualified person acts recklessly. In addition, the committee may wish to note that the immunity afforded to financial institutions differs from the immunity provided to qualified persons, in that subsection A has the language of bad faith or acting with malicious purpose, and that subsection B part does not. Page 12 provides for 13-1-706, which provides that the financial institution shall provide access to the records relevant to suspected financial exploitation of a vulnerable adult to certain agencies or departments. Section 2 on page 13 provides rulemaking authority to the Department of Family Services, and Section 3 provides for an effective date. And I'll stand for any questions.
Thank you, Ms. Hanson. Questions for LSO committee? All right, again, thank you. We have Senator Case. Welcome.
Welcome. Thank you very much. How are you, Mr. Chairman and the members of the committee? Good to be here today. I think the bill's coming along very nicely. There's folks going to testify after me that would probably address some of the specifics about the staff comments. I think in particular, I like the withdrawing of immunity if there's bad actions. I also don't think we need to define the word exploitation. It's kind of feeds into the next definition, which is financial exploitation. I don't think we need that. So I commend the staff. I think there are folks from AARP in the department, and Mr. Meyer is going to be testifying remotely, and I hope that we could give him a little latitude. He's at the hospital with someone very close to him, and he may need a little deference here. So thank you very much.
Mr. Meyer? Senator Case, Mr. Meyer is actually here with us this morning.
Oh, is he? He lied to me. I misunderstood, Madam Chairman. I'm sorry. I apologize. Well, our prayers are with him. That's for darn sure. It's very serious.
All right, thank you, Senator Case. So, do you have any remarks that you just want to go to the room?
That's all I have, Mr. Chairman.
Okay. All right, perfect. Well, I will go to our Department of Family Services first. And I believe we have Ms. Carlson online as well. Let's go ahead and let her in. We will get to Mr. Meyer, and we will get to Mr. Laycock as well, and anyone else who wants to testify, but we'll start with our department. Director.
Good morning, Mr. Chairman, Madam Co-Chairwoman, members of the committee. My name is Corin Schmidt. I'm the Director of the Wyoming Department of Family Services. As we've discussed in previous testimony, we think this bill would be helpful in order for us to be able to better respond quickly to suspected financial exploitation. Our ongoing concern has always been that the money gets out the door faster than we have no way to be able to retrieve any of the exploitation, even if we are able to find that there was a guilty party. I agree with Senator Case and also the staff comment about eliminating the exploitation definition. We have an exploitation definition in the Adult Protective Services statutes and the Vulnerable Adult statutes. So I just have some concern that this may create more confusion and really isn't necessary. I really don't have an opinion on the immunity. I think that's a legal question for you all to work through. At the end of the day, we're just interested in being able to partner quicker with the banks in order to preserve people's finances.
Okay, anything else, Director?
Mr. Chairman, no, I stand for questions.
All right. Vice Chairman Washit and then Representative Craig.
Hey, Mr. Chair, Director Schmidt, the bill draft calls for allowing banks to make contact with third parties who they do not believe to be involved in the exploitation. But my concern, I guess, is that they may not know who all is involved in the exploitation. From your perspective, if a bank were to contact a family member thinking they were doing a good thing, could that complicate the investigative process from your end?
Mr. Chairman, Representative Washit, yes, I could see that could be a complicating factor because in the early days, we may not know who is involved. in regard to the banks, though, I can understand that they may have an existing relationship with families over time. And so rather than maybe having to pull in the system right away, that they could have some opportunity to resolve the issue. But yeah, I think it comes with pros and cons.
Representative Craigo.
Thank you, Mr. Chairman. Director, one of my concerns with the bill draft as it sets now is the initial hold that the banks can institute is 10 days, which 10 business days, which can be 2 weeks. And that seems like a very long time to tie up somebody's money as a depositor within their bank, and without the additional request from, for example, your agency. And I understand part of that is they have to file the report, get it to your agency, let one of your field agents look at the case, and maybe they know the people, maybe they don't, maybe they know the situation, maybe they don't. If we were to lower that 10 business days to some number below that, what kind of effect would that have on your staff, on your field agents? Can we do that? Because that's, I guess, one of my sticking points with the bill draft.
Mr. Chairman, Representative Craigo, at this point, we are just happy to allow the banks to have that authority to put a pause. So the difference between 5 days and 10 days in terms of practice issues is probably going to be negligible because right now we have nothing. So I don't necessarily see any big concerns other than just the pause to give everyone time to make a determination if there is. Just a little bit of anecdotal evidence. I was in Thermopolis a couple weeks ago, and we had 2 adult protective services cases involving exploitation, one of them which was with a bank, and they did reach out to us, and we were able to intervene, but time really is of the essence. That vulnerable adult was on her way to purchasing a camper for a stranger.
Representative Provenza.
Thank you, Mr. Chairman. Director, the staff comment or some of the conversation has been about the word qualified person reporting, so the person reporting to you having to be qualified, and the previous bill having just an employee. Does that qualified person bring you any pause or maybe confusion for your staff in terms of like who you can accept that report from?
Director.
Mr. Chairman, Representative Provenza, I kind of flagged that too. I wasn't sure how concerned we were about that, but now that you asked the question, my concern would be is that if there's any reason that delays the report, so if a bank's chain of command has it fairly strict and therefore you have to work your way up in order to get that qualified reporter, that would concern me just in the delay. We see that in our schools sometimes, where there's a chain of command to make a report on abuse and neglect. And sometimes that can get a little complicated just within any organization.
Additional questions, committee, in the virtual world? No? All right. Thank you, Director, for your testimony. We do have Ms. Carlson virtually. Go ahead and bring her in.
Good morning, everyone. Hello, Mr. Chairman. I would just let everybody know that from the standpoint of DFS, I agree with Director Schmidt, and we are okay with the bill other than just the concerns that Director Schmidt brought up.
All right. Committee, questions for Ms. Carlson? All right, we do appreciate your testimony and you joining us. Let's bring Mr. Meyer up now. Oh, I'm sorry, Division of Banking. Thank you, Scott. Commissioner Bishop.
Was the staff comment regarding including a special purpose depository institution in the definition. I think the definition of financial institution points to a different section of Title 13, which includes a bank, and it doesn't actually define bank there, so you go through the definition of bank in 13.1, 101A1, and that definition of bank already does include a special purpose depository institution, so I think the way it is written, it is included. I default to LSO to make sure of that, but that was really the only comment I had on the language of the bill. Obviously, the only thing that the Division of Banking would be involved with is ensuring that banks develop the appropriate policies that are outlined in here. I think everything else having to do with this bill does go to Family Services, which I think is also appropriate. So I don't have any other comments, but if there's any questions on that matter.
Thank you, Commissioner. Are there questions for the Division of Banking Committee? Nope, none in the virtual. Thank you, Commissioner.
Thank you.
All right. Mr. Meyer, unless you want to defer again to someone I'm missing, then I appreciate you keeping me on task.
Thank you, members of the committee. Mr. Chairman, Ms. Co-Chairman Scott Meyer with the Wyoming Bankers Association. My credits go out to, especially to the LSO. I think they've done a very fine job here, and it's a very good bill. I have a couple of just a little comments, I guess, as I'm looking through. In 13.1.702, and I'm looking on at the bottom of page 5 and on page 6, and certainly want to defer as much as I can to the DFS and whatever there's needed. But it seems to me that if I'm reading that section, subparagraph B, it reads in there that the financial institution shall assess the suspected financial exploitation and submit a report. And I think that it would make sense to me that if on that line 5 we said suspected financial exploitation and, comma, if warranted, comma, submit a report, because once we take a look at this, there may be some reasons to understand exactly why, and I don't think that it probably is necessary to file a report right away unless we actually believe that there is exploitation taking place.
Mr. Meyer, can you restate that location?
Yes, it's on page 6, line 5, that reads exploitation and then I would insert comma, if warranted, comma, then it goes on to say submit a report to the department. I think also, and I will really defer a lot to DFS, but on page 8 of where it starts with section 13.1.703, notifying the vulnerable adults, the situation that I guess I'm looking at, and I know I've had some opportunity to talk with some of you about this, but the idea of having that third party being able to notify them is that, you know, hypothetically, if son is using mom's account to buy an F-350, that may raise some questions, but if the third person that they notify is somebody other than the son, and they find out that, no, mom really wanted to buy son an F-350, he could use it, son's been doing a great job taking care of mom and the family's okay with that, then it would seem to me that notifying a third party and filing a report with the DFS is probably not warranted. It seems like that at the time, maybe it's all right for a financial institution just to reach out to that third party. Having heard the testimony from Director Schmidt today, I understand exactly where they're coming from, and I don't want to, inhibit their ability to do their investigation. My suggestion, I guess, at this point in time is on that line, or on that page 8, is to delete lines 4, 5, and part of 6, and then have it start with the financial institution, and then delete 7, and part of 8 just says the financial institution may also notify a third party. That way, we may avoid a whole lot of reporting and what have you of submitting of reports in a case where it really is consented to by the adult that's at question here. But again, I don't want to step on the fingers of and the toes of those who are trying to enforce this, and I can understand that if they thought maybe everybody's in collusion, it would maybe hinder their ability to investigate. I think going over to page 9, as I look at that and just addressing a question that Representative Crago brought up regarding the 10 days, at least the statute right now says shall not exceed 10 days, as opposed to it'll hold it for 10 days. And so if we thought it was going to be less, that's fine. But I think the 10 days seems to be a pretty good marker around the country. Some of them have 30, some have more, but I think 10 days at least gives financial institution and DFS a chance to investigate this and make sure that they have it. And so I would encourage to stay with at least, not to exceed 10 days, and if we need more, then that's where you can seek additional remedies under this bill. As far as, and this may be just a term of art, I don't know how this works with LSO and with the legislature, but on page 12, it talks about who has to keep records, and then I think like on line 15 and 17, they both refer to district attorney's office. So I'm going to leave that to you folks, but as I understand it, and this is certainly not my area of the law, but my understanding is that Wyoming has 2 counties that have district attorneys, the rest of us have county attorneys that are prosecuting. Whether that just needs to say prosecuting attorney like it was before, or if that's just a term of art that the legislature uses. I just bring that up as just a question of how that works. And then finally, I think on page 13, under that 13-1706 that starts on 12, it says section 2 and section 3, but I did not know if there's a section 1. I just looked like kind of hanging out there a little bit. But other than that, I think it's a very good bill. I think it's much cleaner than we had before, and the Wyoming Bankers Association stands in support of this bill.
Thank you, Mr. Meyer. Committee questions, go to Representative Yen and then Representative Oakley.
Mr. Chairman, thank you, Mr. Meyer. So going through this bill, I think overall I like it. I am concerned on the immunity portion, whether it is too broad. So I think I'm reasonably okay with immunity from civil liability, but criminal liability immunity seems quite broad. And so I tried to look up what other states had done, and it looked like Nebraska didn't include criminal liability immunity in there. And I'm interested in what your viewpoint on having that in or out would be, Mr. Meyer.
Mr. Meyer.
Mr. Chairman, Representative Yen, my thought is on that is that it would alleviate the question of whether they could prosecute, but understanding that the prosecution has probably a very high bar to meet in order to prosecute. Maybe one of the reasons why Nebraska has not, but the majority of the states all have civil and criminal. And I thought in the sense of unity and uniformity throughout the United States, that this makes a lot of sense.
Okay. Representative Oakley.
Thank you, Mr. Chair. Thank you, Mr. Meyer. I wanted to go, you were on page 8, section 703, talking about lines 4 and 5. And I guess kind of what you suggested, I didn't really, just when at first glance, I didn't feel like it changed anything. So I kind of want to understand exactly what you're getting at to see if I think there does, if I agree there does need to be a fix. But so lines 6 and 7, just starting there, the financial institution may, at the time the financial institution submits a report, also notify a third party. So does the word may there alleviate your concerns, which it's already in there, and you were kind of suggesting a fix, so it seems like it doesn't, but I'm trying to understand, from what you said, I didn't see any change from the current language. So if you could discuss that a little more and what you're thinking.
Sure. Mr. Chairman, Representative Oakley, I guess the point that I'm trying to make is it starts on line 4 as well, and then later on in line 7, it talks about when they submit a report, they can reach out to the third party. And my thought was to eliminate that requirement that a report gets submitted before they notify a third party. I think as Director Schmidt says, yes, there are a lot of families, and maybe the financial institution knows that family, and maybe they understand and they can reach out to, the designated person that the adult has named in their account as to who to reach without having to submit a report to reach out to them.
Representative Grego?
Thank you, Mr. Chairman. Mr. Meyer, I guess I'm kind of on the same page with Representative Yin and was wondering about the criminal liability immunity as well. Just maybe to help us all understand why it's in there. Do you have an example or examples of what kind of crimes we would be excluding from liability under the bill draft?
Mr. Meyer?
Mr. Chairman, Representative Craigo, I can't think of any right off the top of my head. I guess if there was some kind of a collusion going on between the financial institution and maybe a member of the family that's taking advantage of it, that you could be charged with aiding and abetting or something like that. I can't imagine that happening because they would be the ones that would be notifying DFS and law enforcement. But honestly, the idea really was just to keep the uniformity that we have with majority of the states.
Mr. Co-Chairman, about false reporting.
Thank you. That's a good point.
Representative Oakley?
Thank you, Mr. Chair. I guess what's interesting to me about that is, then of course it says unless it's not acting in, unless there's bad faith, which, I mean, almost inherently, right? There's bad faith in the criminal act. So I don't know. I don't know where I fall down on it, but it just seems like, I mean, it says you're immune from it, but if you're doing a criminal act and it's in bad faith, then you're not immune from it. So I don't know what the fix is there, but it doesn't seem to fit somehow.
Representative Grego?
Mr. Chairman, not a question, but just a thought, I guess, to follow up to Representative Oakley is, I don't know banking law. And that's, I guess, why I was asking Mr. Meyer. I mean, there are some probably strict liability type laws that don't require intent or bad faith. And so I just was curious if they were aware of any that I have no idea. I don't delve into that area of the law. And so just be interesting going forward if maybe we could get some information on that. Thank you.
Mr. Chairman, Representative Grego, I will get you some information on that for sure. I think, as I've mentioned to the committee before, I think this is one of the most highly regulated industries. There's not much that you can do without our director back there not knowing what we're doing and asking questions. So I will explore that a little bit and get right back to you.
Okay. Representative Provenza?
Thank you, Mr. Chairman, and this might be a question for some of my colleagues or law enforcement, but if we include that immunity for criminal liability, does that impede in any way to maybe look into a criminal investigation if there are questions from a prosecuting office as to whether that's available or not?
All right.
Well, Mr. Chairman and Representative Provenza, I don't think that does. I don't think that would inhibit law enforcement from looking at everything that the financial institution is doing.
Co-Chairman?
Mr. Co-Chairman, thank you. Before we get into the realm of discussion on the topic, I would be remiss in that providing criminal immunity to anyone for anything in our statutes should never be done, except under the rarest of circumstances, and this isn't it.
Well, Mr. Chairman and Co-Chairman Nethercott, that is not a hill I'm willing to die on. I certainly agree with that.
Good. All right. Thank you, Mr. Meyer. Ms. Chambers, come on up.
Good morning. My name is Kara Chambers. I am the Director of the Division of Victim Services. Sorry about that. I just wanted to briefly bring some things to your attention. These types of activities are some of the most heartbreaking calls that my office receives. Because while the Division of Victim Services is able to assist elders in some capacity with financial crimes, it's actually the only category of victim, if it's a vulnerable adult or elder abuse situation, that we can help with a financial type crime. But what we cannot do is restore their funds. We can provide financial counseling or assistance with that, but that's usually after the fact and after they've learned a very hard lesson already. In particular, we see calls for catfishing scenarios, if you're familiar with that term, lottery fraud, gift card fraud, wire fraud transactions, and the like. And again, these are some of the most heartbreaking calls that we receive. I'm anecdotally aware of a case where a gentleman through a lottery fraud scheme was defrauded out of $400,000. And again, very little my office can do very much after the fact. And so I wanted you to be aware that this is a real problem that we do see. And we're so far behind the 8 ball within my division to help these folks that this is very exciting for my agency to see this bill. I also wanted to make a brief comment about the immunity provision, only to the extent that, similar to mandatory reporting, the mandatory reporting law is essentially immunity from liability for if you suspect abuse of whether it's a child or a vulnerable adult, that just reporting it, in good faith, you can't be held, liable for, as Senator Nettercott mentioned, false reporting or things like that, unless there's a bad act. So I would just mention that concept of reporting suspected victimization, that concept of immunity for that is found elsewhere in the law. So wanted to make you aware of that. And with that, I would just stand for any questions.
Co-Chairman.
Mr. Co-Chairman, thank you. Want a couple of things to LSO, buy you some time here. Curious to know if you can quickly find how often criminal immunity is offered under our laws to anyone under any circumstance. Good luck. Then two, back to Ms. Chambers, concerning the kind of fact situation that you've identified of maybe vulnerable adults being victims to fraud schemes, but not necessarily involving their banks necessarily per se, or that kind of concern contemplated by this bill. Is there some type of statutory change that we could make to allow for some type of compensation for those victims?
Ms. Chambers.
Madam Chair, it would require changing the compensation program statutes. I will say currently there's a financial cap of 15,000. I think this would quickly bankrupt my division. But certainly, if you contemplated changes in the law of what we were able to assist with, that would be how you would have to do it. The unfortunate thing is 15,000 would be a small amount of the sort of questions and claims we see. But yes, and I realize that this bill isn't exactly addressing what we get calls on, but I do think with this law, we'll give advocates in victim services the understanding that, look, we take this seriously, we're looking at this type of thing, and quite frankly, education to retail and other outlets that might be able to suspect something's going on would be certainly helpful, and I know that that's something that we try to do, but I do think this is a step in the right direction to protect victims. Again, while it might not be addressing all the scenarios that I referenced, it's certainly putting something out there.
Yeah, Ms. Chambers, real briefly, and not want to get too off topic and outside the bill topic, but this issue I care deeply about. And so do you think that there could be some type of statutory amendments addressing crime victim compensation for known fraud schemes? Because oftentimes these bad actors aren't easily identifiable, and it's not necessarily a local crime. They get contacted online or on the telephone, and they don't necessarily know who even the bad actor may be. And law enforcement doesn't really have the ability to track that down. And then in many times, their actions become voluntary as a result of being deceived or coerced in some manner as a result of being vulnerable. And so our typical triggering events associated with the reporting of a crime and or the adjudication of a crime don't exist. And so, and then understanding too that the amounts of losses that these victims experience would probably zero out the Crime Victims Compensation Fund. And so some type of, obviously, amount limitation associated with that recovery and then required training to go along with it. Is that something that you could work towards maybe reaching out to some of us members on for a solution?
Ms. Chambers?
Madam Chair. Yes, so very briefly, in order for someone to be eligible for crime victims compensation, it doesn't need to be reported to law enforcement. We don't require an arrest, we don't require prosecution, and we certainly don't require a conviction. The change that you would, or perhaps contemplating, would be allowing the fund to be used to offset financial loss, and property loss, which we are prohibited from doing. So that would need to change that language. For example, if you are a victim of a drunk driver, a DUI, you're hit by a drunk driver, we cover medical, mental health. We don't cover anything related to the automobile or the property. And usually that's because it's covered through other collateral resources. But that is something that you could perhaps, but again, I do worry that even the 15,000 cap, which I'd be reluctant to go above because of the financial situation of the state. If you'll recall, we started with a surcharge bill. But yeah, it might be something that we would need to address, perhaps in statute and possibly in our policy and guidelines. I will let you know that there are some federal funds that come into play in compensation, because that does make up a portion of it, and I'd have to make sure that we were only using state fund for that portion, but that's doable. So there's a lot of moving parts, but that's something to consider. Because again, right as it exists, the only financial, it is a caveat already that we can help vulnerable adults with financial exploitation, but again, it's everything except replacing the lost property for the funds. So it doesn't get utilized that much, because really what they want is their money back. And so.
Additional questions for Ms. Chambers? All right.
Thank you.
Thanks. Mr. Laycock. Welcome.
Be brief in speaking in support of this bill. I want to thank you for continuing your work to create protections against financial exploitation and abuse. We've been very supportive of this legislation through the interim. We like what we believe to be the added protection from fraud that the bill allows. We appreciate the fact that Wyoming won't be a guinea pig with this particular bill, given the fact that 34 other states have done something with the model legislation in front of you. Meanwhile, we have noted that reports to law enforcement and consumer protection agencies around fraud attempts have gone up in the states that have passed similar legislation. Just as a reminder, as of July 2021, this model act has been adopted in whole or in part by states such as Texas, Alabama, Utah, Oklahoma, North Dakota, and Nebraska. I did want to point out an AARP report released October 4th that shows the rate of financial exploitation targeting older adults has more than doubled since the start of the pandemic. And that's likely a pretty small estimate, given the fact that we figure about 1 out of every 44 older adults actually reports the exploitation. Those numbers go down when it's someone that they feel like they trust and know. That same report recommends solutions that come from all angles and emphasizes the proven effectiveness of freezing or delaying or rejecting suspicious transactions to prevent theft before it occurs. By implementing resources and policies that allow the employees to take these actions, financial organizations can empower the front line to activate as the last critical line of defense. Another proven method is the adoption of the Trusted Contact Form, which offers customers a chance to designate someone they trust to be contacted by a financial institution if there is fraud taking place. So in short, thank you very much for your time. We appreciate the time that you've given this particular bill as well as the thought. There have been a lot of really great questions that have come out. So I'll stand for any questions.
Thank you, Mr. Laycock. Co-Chairman Nethercott.
Thank you. Thank you, Mr. Laycock, and all the work that AARP does on this front. I think it's actually quite a bit on warnings and educational outreach concerning these types of fraud schemes and these types of victimizations that the bill also contemplates. Just a side note and kind of an odd thing, does AARP offer any type of something similar to insurance coverage or protections or loss associated with these types of crimes?
Mr. Laycock.
Mr. Chairman, Co-Chairman Nethercott, we don't necessarily. We do, as you mentioned, quite a bit in the world of fraud education, or fraud prevention education. It probably sounds better. Specifically, we have a bank safe program that helps banks, credit unions. It's a free program to help them spot fraud. The Federal Trade Commission liked what we did in that space enough to actually contract with AARP to do the same for organizations, businesses that sell gift cards, because we see a ton of gift card scams that move around from place to place. So our world probably operates a little bit in the education space, a little less on the insurance space.
Committee, any additional questions for Mr. Laycock, AARP? No? All right, well, we do appreciate your testimony.
Thank you for the time.
Any additional public comment in the virtual world? Any additional public comment here? All right, with that, I will close public comment. Any amendments on this bill? Committee, discussion on the bill? Oh,
Move the bill?
I'm sorry. What is your pleasure, committee? Representative Yin, move the bill.
Move the bill, Mr. Chairman.
Okay, seconded by Senator Cost. Now we can have amendments or discuss this bill.
Mr. Chairman, if I may.
Yep.
So I would like to, I'm trying to pull it up, but I would like to amend the bill to strike the criminal immunity. So I would motion for that.
That's seconded by Representative Craigo. Discussion on this amendment? Mr. Fuller?
Yes, Mr. Chairman. Chairman Nethercott, in response to your question, this is not scientific or necessarily thorough. I found approximately 10 instances of expressly granting criminal liability. They range from the neglect statutes, the statutes dealing with newborns, corporal discipline in schools, the issuance of driver's license, the prescription of epinephrine, peace officers investigating controlled substance violations, drug donation program, and then perhaps most notably, the Adult Protective Services Act provides both civil and criminal liability regarding the reporting of potential exploitation.
Oh. Strike all those while we're at it.
Second that.
Mr. Chairman, if I may. So I do think the bar for criminal proceedings tends to be higher, and so I do think it's appropriate to strike this here. If the banking association comes to us during the session and says, here's a reasonable situation where it makes sense to strike criminal liability, I think that's fine. We could add it back in during the session, but I think it is more prudent to take the conservative route here and not have criminal liability immunity. Thank you, Mr. Chairman.
Thank you, Representative Yin. Representative Craigo.
Thank you, Mr. Chairman. I would also note there's two different standards within the bill itself regarding criminal liability between Part A and Part B under the immunity section. And so the bad faith / malicious purpose only applies to Part A. It doesn't apply to Part B. And so, and that's part of my impetus for seconding the motion and wanting to strike the words criminal from both of those sections at this point.
Further discussion on this amendment? All right, question on the amendment. All those in favor signify by saying aye. Aye. All those opposed, no. That amendment's carried. Additional amendments? Representative Craigo?
Thank you, Mr. Chairman. Page 9, line 15. I would like to reduce the 10-day business hold down to 5 days. So on line 15, just make 10-5.
Moved by Representative Craigo and seconded by Representative Oakley. Any discussion on this amendment? Representative Craigo?
Thank you, Mr. Chairman. I just feel like 10's a long time. It can be up to 2 weeks, and it's 11 days because it says 10 days after the date of the hold, and so it's actually 11 business days. That's a long time. I think DFS or local law enforcement within 5 days, actually 6 because it doesn't include the day of the report, can surely figure out or make a decision or help the bank make a decision whether or not an additional 30 days is necessary. So that's the reasoning behind my motion.
Okay. Any other discussion on this amendment? All those in favor signify by saying aye. Aye. All those opposed? That amendment is passed. Any additional amendments? Representative Provenza?
Thank you, Mr. Chairman. To go back to the staff comment that I think may start on page 5 with the concern of whether we have an employee or a qualified person, I would like to strike the definition of qualified person from page 4, lines 25 through 26, page 5, lines 1 through 2, and then on page 5, line 10, change that language to an employee of a financial institution, and maybe where LSO sees fit. We don't need to include the entire employee of a financial institution, but just an employee. That's also on, so page 5, line 10, line 12, page 7, line 8, page 10, line 15, and line 19, and then page 11, line 1.
Seconded by Representative Yin. Yeah.
Yes. So just striking out that qualified person, that would be on so the definition, page 4, lines 25 through 26, 5, 1 through 2, page 5 is line 10, and then same page, line 12, page 7, line 8, page 10, line 15, and then line 19, and then page 11, line 1. And just for background on that, in my question with DFS, that question being, does that kind of added bureaucracy or question of who's a qualified person maybe slow that process down or make it more difficult to know who to accept a report from, or even internally having conversations about who's going to report. And if there is an instance in which there's a bad actor within that institution and another employee knows that, maybe not a qualified person, it would be, I think, a beneficial thing for other people to be able to report that as well.
Okay, additional discussion on this amendment? A lot here. Ready to vote? Okay, all those in favor signify by saying aye. All those opposed? No. All right, that amendment has not passed. Vice Chairman Washit.
Thank you, Mr. Chairman. I'd like to make a motion to delete page 8, lines 1 through 12. This is the section on notifying third parties. Just seems to me that I'll wait for a second, then I'll comment.
Okay. We have a second. Seconded by Representative Rodriguez Williams. You may discuss that motion, Vice Chairman Washit.
Thank you, Mr. Chairman. It seems to me that this section kind of jumps the gun in that the day that the report is filed, the bank is notifying this third party. The third party can be notified by the investigator from the department as they're seeking an understanding of whether or not there was exploitation or not. But to allow the bank to, or even encourage the bank to contact family members seems to me to be preempting the investigation. And we heard testimony from the director that that might be the case. So I would suggest that while it may be the case that the family member can resolve the issue very quickly, I think that contact should be made by the department rather than by the bank. So I think this deletion is appropriate.
Additional discussion on this amendment? Seeing none, all those in favor signify by saying aye. Aye. All those opposed? Okay, we're gonna do a show of hands because I do have hands going up on virtual as well. All those in favor of this amendment, raise your hand. 1, 2, 3, 4, 5. Okay, all those opposed? That amendment has failed. Additional amendments or discussion on this bill? Representative Craigo.
Thank you, Mr. Chairman. Page 6, line 5, and this is Mr. Meyer's requested amendment. Line 5, after the word "and," we would insert a comma, the words "if warranted," and then another comma.
Second.
Seconded by Co-Chairman Nethercott. Discussion was, this was Mr. Meyer's amendment. Go ahead, Representative Craigo.
Thank you, Mr. Chairman. Just the short discussion on this. It does make sense to me that if an employee or a person within the bank makes a report to the institution and they run down all, somebody in the bank might know exactly what's going on, and so they may not necessarily need to submit a report or take further action with DFS or local law enforcement, and this language would allow them to not actually file a report if the bank discovers that there's not really an issue there.
Question on the amendment. All those in favor signify by saying aye. Aye. All those opposed? All right, this amendment carries. Any other amendments to this bill?
Mr. Chairman,
1 second, Senator Case. Representative Oakley?
Thank you, Mr. Chair. According to discussion, we've heard a couple times that defining exploitation in this section, when it's defined in Title 35, may be confusing, not only duplicative, but actually different. I'm going to make the motion to delete the definition of exploitation in this section, page 2, lines 15 through 20.
Seconded by Senator Cooper. Discussion on this amendment? Guess we just had it. All right, you ready to vote? All those in favor of the amendment signify by saying aye. Aye. And those opposed? That amendment carries. Senator Case?
Mr. Chairman, you just took care of the issue I was trying to get your attention on. Thank you.
Oh, all right. Senator Cooper, did you have something?
Mr. Chairman, Representative Oakley's took care of that for me.
All minds were ready to take care of that. All right. Good job. Good job, guys. Any other amendments or discussion on this bill? Just double checking in our virtual world, since we've got a little bit of a lag between us and them. No? Okay. Question on the bill. Roll call on the bill LSO for draft 23 LSO 0279.
Senator Cooper? Aye. Senator French?
No.
Senator Kolb excused. Senator Cost? Aye. Representative Craigo?
Aye.
Representative Larson?
No.
Representative Oakley,
Aye.
Representative Provenza,
Aye.
Representative Rodriguez-Williams,
No.
Representative Washut,
Aye.
Representative Yin,
Aye.
Representative Zwanitzer,
Actually, I believe he left a proxy. Did he leave a proxy vote? Thought he told me he was going to. Nope, he's excused. He thought he would be back maybe.
Co-Chairman Nethercott. Chairman Olson,
Aye.
that passes.
All right, making good progress this morning. We continue to be ahead. We are 50 minutes ahead of schedule. School crossings, we are starting early. Hopefully that still means that those who are interested in this bill are here. We have a bill draft 23 LSO 0283, and which attorney will be introducing this bill to us? Mr. Fuller? All right.
Okay, Mr. Chairman, 23 LSO 283 Working Draft 0.4 School Crosswalks and Pedestrian Crossings Appropriation. This is 4-01 in the online meeting materials. The committee requested this bill in September to appropriate funds for grants for the construction and improvement of school crosswalks, including the construction of pedestrian bridges. Page 1, line 11, appropriates $10 million from the general fund to the Department of Transportation for the period beginning with the effective date of this act, which would be immediate until June 30, 2028, for purposes of providing funds for school crosswalk projects on both state highways and on roadways of cities, towns, and counties, in accordance with the rest of this bill draft. The remaining language on page 2, lines 6 through 12 is the standard appropriations language and makes clear that this is the intent of the legislature is that this is a one-time appropriation. Then page 2, line 14, conditions the expenditure of these funds on the following. So on page 2, line 19, the funds can only be expended on improvements to crosswalks within school zones with reduced speed limits, or where the crosswalk is immediately adjacent to a school facility. Page 3, line 1, improvements to crosswalks associated with this appropriation include the construction and installation of pedestrian overpasses, pedestrian underpasses and tunnels, and then improvements to existing school crosswalks, including improvements to existing overpasses and underpasses, signage, lighting, and the roadway adjacent to that crosswalk. Then page 3, line 15, this language is intended to reflect the discussion in September, and I believe the initial motion of the draft, and this is intended to reflect that. So this is a priority list for the expenditure and distribution of funds for school crosswalks in the following order. So page 3, line 19, school crosswalks where a fatality has occurred within the last 2 years. Then where an injury or other accident has occurred. And then finally on page 4, any other school crosswalk where the department determines a need for an improvement. Page 4, line 6 would require the distribution of funds by July 1st, 2024, and then all projects must be completed by June 30, 2028. With that, Mr. Chairman, I stand for questions.
Senator Cost.
Thank you, Mr. Chairman. Mr. Fuller, when you say adjacent to a school, I'm thinking of a couple of situations where it's really not adjacent to a school. There's a situation in Cody that's close, but it's not adjacent. What's your definition of adjacent so I have a better understanding of what that would
Mr. Fuller?
Yeah, Mr. Chairman, Senator Cost, I think without a specific definition, be the plain language, and adjacent would be, pretty close, yeah.
Yeah, and the word before it is immediately. So not only is it next to, but it's immediately next to. Or adjacent. Senator Cost?
Thank you, Mr. Chairman. I'm concerned with that because I know of two situations, one in Powell, one in Cody, where there's really not adjacent, but they've had injuries at both places. That worries me a little bit.
Mr. Fuller, is there a quick and easy, reasonable way to expand this language? Where did you come up with immediately adjacent and why? Just thought at the time it was.
And Mr. Chairman, I think that was more in line with the discussion about a particular issue that occurred. That was more the genesis of the language rather than, other crosswalks elsewhere in the state.
So it could be within reasonable proximity to a school facility.
Yeah, Mr. Co-Chairman, if I may, and Mr. Fuller, this is not for you per se. I think before we start discussing that particular issue on the bill, there's a number of solutions. One could be in the vicinity of, or in the reverse, right? If there's a location where children or pedestrians are crossing on their way to school that is not a crosswalk, seems much easier to create one, and then put have this funding be available for those purposes. So I think that may not be, there's a number of ways to find a solution to that particular issue.
Okay.
And Mr. Chairman, Senator Cots, perhaps to your point, is directly en route would be one option.
That's why he's.
Other Representative Yen?
Mr. Chairman, so I think as Mr. Fuller pointed out, this whole legislation was in response to constituent testimony that came to us over safety concerns in a specific area. Well, we can't, as we all found out last meeting, if we didn't know already, we can't pass specific legislation, but we can put certain requirements that projects would have to fulfill. So I do want to make sure that specific crosswalk would fall under these requirements without making it too broad where it would never see any funding at all.
Mr. Co-Chairman, thank you. I might be able to answer that. I think it's possible that funding might apply to this particular situation. It certainly would apply to others or potentially even more high-risk crosswalks, even though what occurred might indicate that that's a pretty high-risk area. There may be others that are identified as presenting a greater risk that would be also appropriate.
Mr. Chairman,
Yes.
Representative Yen, that's really, I think, the genesis of the priority list and requiring the projects to be prioritized in that order as listed on pages 3 and the top of page 4.
Welcome, Director.
Mr. Chairman, members of the committee, thank you. Pleasure to be here today. And let me certainly thank you all for bringing this important topic in front of us, and really, Mr. Fuller, for a good draft here. I am, for the record, Luke Reiner, Director of YDOT. Joined with me is Mr. Keith Fulton, who is our Assistant Chief Engineer for Planning. And really, I think what I might do is make a couple comments, and then I do have probably a few recommended amendments to this, some that I think will address the concerns that I've heard already. As we look at this issue, certainly, as we testified, I believe it was up in Casper, it's an issue across the state, and it does continue to be an issue. And it's one that we take seriously and certainly need to look at. As we looked at this, this concept of an extra $10 million coming, really to the department with a specific task and purpose of supporting crosswalks, we really probably took a bigger view of it than just crosswalks right opposite schools, and really took sort of this concept of safe routes to school, which may be a term that you're familiar with in the past. But, you look at the incident that occurred in Lander, which I think we talked about last time. That young lady was certainly on her way, but it was not proximate to the school. And we think we got to pay attention to some of those events. And we just had an event here in Cheyenne recently on Central Street, right? Which is really, again, the same type of issue of hey, where are pedestrians, specifically in this case, our younger group that we're so concerned about crossing the road, and how do we facilitate a safe passage? And so that's really the approach that we took. I do think that the prioritization that's on page 3 and goes on then to page 4 makes sense to us. But perhaps maybe in a way of maybe walking through the bill with some potential amendments. With your permission, Mr. Chairman, I'll just do that. I think, was there some, were the amendments passed out, the proposed amendments? Okay, thank you. So you should have a sheet in front of you that really looks like this. And I'll just start on page 2 then, on line 19 to 23. And what I'd say there is you can see that our concept there is to talk about, hey, listen, we want a plan. Now, I think just backing up 1 sec is our rule when we give out transportation alternative dollars, which is really what these type of dollars we see augmenting. So when we talk, every year, in fact, this year we received about $10 million in transportation alternatives money. And that's money that really goes out to local communities that supports bike paths or crosswalks or pedestrian crossings or underpasses or that variety of stuff. There's fierce competition for that money. And if you remember the brief we gave you up in Casper, that was on the last couple pages on how that process worked. And really what we see is what our intent would be that we would use, if this bill passes, that we would take this money and we would really put it in that pot and treat it like that, with the same type of process, segregated for this purpose, but the same type of process. And so what we do know is right now is we always require a comprehensive plan before we give money for projects. And so for the first money we always give is money for a plan, because it's not helpful often just to put in a structure, because it's got to work with everything else around it. And you sort of got to have this transportation plan to make sure that, hey, if you're going to put a crossing here, maybe we got to put up a fence to get kids to cross there, or maybe we got to turn the road to a one-way. And so it sort of becomes more of a comprehensive plan. And so our first recommendation in terms of amendments would be on to add, as you see on page 2, line 19 to 23, the after the term crosswalks on line 21, the words identified in a local transportation plan, and I'd ask you to change that and to an or that are located. And so that makes it broader, and it requires a plan as we go forward. So that's our first recommendation, say, hey, let's do this deliberately with purpose, knowing where we want to end up in that certain location. So then if you flip over, then our next concept is on page 3, lines 4 through 7, and where it talks about how we would spend the money. And if you look at line 4, it says construction and installation of pedestrian overpasses. We would also recommend that we're authorized to use the money for planning and design so that it's a package deal. And so those are that would be our second recommended amendment, to add planning and design in both paragraph A and B on page 3. And then our next suggestion on this, on page 3 in line 12, is to add the word signals to what we're authorized to spend the money on. Because right now we think, there's certainly signals that might be used. Sometimes you talk about, a high amplitude blinker, flashing device and other signs like that. And we didn't think that was included. So we'd certainly recommend adding the word signals. And then if you flip over then to page 4, we would recommend that after the paragraph C, that you would add a paragraph D that says, in this concept of, hey, let's make this a little bit broader than exactly around schools, is to add any school crosswalk identified in a local transportation plan, so that it's more comprehensive. Then the next suggestion that we would have is, again, on page 4, Bowlegs, triple I. And really, as you think about how funding like this works, it will take us a while to compete the projects. It will take us a while to design the projects, and to send the money out by 2024 for us as a department would be problematic. And so my recommendation would be is like, hey, just say, hey, we've got to have this money spent by 2028, or that's already in there. So you could probably just delete that entire paragraph. I would offer, if you're interested in exactly what we're doing, we'd be happy to report to you as we go down the line, so that this money will be spent by 2024, or correction, by 2028. But that's what we're in the business of doing, is identifying projects, planning, designing them, and then getting the money spent. But it's, as you know, it takes a little bit of time. And so I just don't think it's realistic for us to send money out to other departments by 2024. And then my last suggestion, Mr. Chairman, if you flip over the page on the suggested amendments, is to really request, and this mirrors language from similar bills, the ability to spend, and our suggestion here is 2% of this money to help administer it. It just, as we're staffed and manned, we are now having to actually go out on a frequent basis to hire consultants to help us do these type of projects. And with the increase in number of projects here, I suspect we're going to have to do the same, and would ask permission to spend some of this money, estimated about 2%, to really administratively support the program. With that, Mr. Chairman, that's really our comments on the bill. We think it's a great idea, a great start, and this would be, our suggestions in how to perhaps make it flow better for us as an agency.
Thank you, Director Reiner. Appreciate you walking us through your amendments here. Committee, do you have any questions for the director about the amendment, or just in general? Vice Chairman Washut.
Mr. Chairman. Mr. Chairman. 2 points and comments, questions, I guess. On Director Reiner, on your first proposed amendment on page 2, line 21, I think I heard you say that you would prefer that we change the word "and" to "or." Is that correct?
Director.
Mr. Chairman, Representative Washut, that was correct, really with the concept of really making it a bit broader, so that it would not have to be exactly within a school zone, but it could be, it might be outside the school zone, but still a crosswalk, to the point that it's been made several times.
Vice Chairman Washut.
Thank you, Mr. Chairman. My concern there is that the way I read that with the "or" is that it could then be used for a school zone that's not included in the transportation plan. That if we have and, then it has to be a school zone and in the plan. If we use or, it could be in the plan or some other school zone. Is that your intent?
Mr. Chairman, Representative Washington, you bring up a brilliant point, and no, that was not our intent. The intent would be that it's in a plan, and that it supports a crosswalk that supports a school. So maybe you could say, maybe the discussion there is identify in a local transportation plan that supports safe routes to schools, or something along those lines, and I'd maybe leave it up to the committee to tweak it. But the intent there was, we want it to be in a plan. That's what we really added there. And then to the discussion of the language of here, where exactly you want it to be, I think that's a discussion of, hey, let's make it support our kids safely getting to school.
Vice Chairman Washit.
Thank you, Mr. Chairman. And my second deals with the proposed amendment on page 3, line 12, adding signals. You see signals as only being electronic, or could they be rumble strip type warnings in the pavement, or is signals broad enough to include all those options?
Director?
Yeah, Mr. Chairman and Representative Washit, when we wrote that, it was very much intended to be electronic. If we wanted to add in rumble strips, my perception would be we probably should add that as a specific line. And maybe let me ask, if you were the permission, what Mr. Fulton would say about that.
Mr. Fuller? Oh, Fulton. I was very confused why Mr. Fuller would have an opinion on rumble strips.
Thank you, Mr. Chairman. Keith Fulton, Assistant Chief Engineer, YDOT. Yes, our intent signals was probably more the electrical side of that. And so I agree with the director to add, if you want to be that specific, include rumble strips or some preemptive warning.
Yeah, and perhaps that would be pavement modifications, or I'm not sure what the engineering term would be on that.
Yeah, you could do rumble strips and or pavement warnings. Either one would work for us.
Okay. Senator Cooper?
Thank you, Mr. Chairman. Director, would you tell me how we identify what is the school zone and who designates that? Because we've got areas that are not necessarily adjacent to the school that we discussed, or we've got areas that are away from the school that need a crossing, but it's not necessarily a designated school zone. In a lot of the smaller towns, there are no designated school zones. So where does that definition come from?
Mr. Chairman, Senator Cooper, I don't know that. I have an idea, but the very specific definition and who defines that, I owe you a response on that. Let me see if Mr. Fulton knows.
Mr. Chairman.
Mr. Fulton? Oh,
I'm sorry. Go ahead, Mr. Fulton, go ahead.
Mr. Chairman, Senator, I don't. I can't add much other than I think it's, our traffic engineering folks would look at that, and depending on the location of a school and the roadways to it.
thank you. Senator Cooper?
Yes, sir. I see a lot of, and maybe I'm mistaken here. You're discussing a lot of things directly related to school zones, but we don't know what a school zone is. Is that correct?
Director.
Mr. Chairman, Senator Cooper, I wouldn't say that's correct. I mean, they're defined for us as out there today. And, they're immediately proximity to a school and there's crosswalks there. What the specific legal definition is what I thought your first question was. And so as I think about, as I drive through school zones on the way to work every day, and as my kids went through them as they went to school, I mean, we knew where they were. I have never sat down and specifically designed what's in the school zone. I mean, they're there and they're operational. And I know that my traffic engineers are involved in the definition of that and defining
We
that.
might have some help here from Mr. Fuller, who might have
Oh.
looked it up in the statutes.
Well, Mr. Fuller, not Mr. Fulton.
Yeah, Mr. Chairman, Senator Cooper, at least for purposes of this bill, the reference to school zone is any place on a roadway where the speed limit is 20. So that's, how that's designated, I couldn't speak to that, but at least for what is referred to on page 2, line 22, that's what's meant by that statute reference.
Mr. Chairman.
Senator Cooper.
I guess we're back to the engineer here. Who's determining this? We had discussions last month or whenever we were in Casper about how people go about, how these entities go about asking for a school zone. You suggested to go to the engineer. The one particular town I was talking about did that, and they said, well, we'll have to do a study, it'll take a while. That was their whole response. I drove through another town last week with a designated school zone and a school crossing, and the school's been closed for 10 years. So what are we missing here? I guess I'm not sure what the process is, and we're limiting funds to school zones when we can't even determine what a school zone is. Can you help me with that a little bit, sir?
Mr. Chairman, Senator Cooper, I'm going back to notes from the past where it says that a designated school zone crossing should be considered, if there's a study that's done that evaluates the traffic stream and the students' use of the crosswalk. And that's what the study is. So in the case where we talked about the community that you talked to about the last time, certainly put that community in contact with the district engineer. They're working through that process. My understanding, that wasn't so much a school crossing as just a crosswalk. So what I know is that when we turn this over to our traffic professionals, they'll figure that out. Typically, it's in concert with, I believe, local law enforcement. And so while I have a lot of confidence that if we say, hey, there's a school crossing there that is appropriately designated, and if there's a school that's not there and there's still one there, we probably should look at pulling that out.
Thank you, sir.
All right. Any additional questions for YDOT? Oh, yeah.
Mr. Chairman.
Larson, go ahead. Did you want to talk, Representative Larson?
Is that for me, Mr. Chairman?
You are Representative Larson. Go ahead. Can you hear me?
I can, okay. This is a question for the director. I guess I'm not sure if he stated the amount of money that they already spend, if it's an annual amount, if it's set and or just a percentage. I'd kind of like that answer. And then I have another question.
Okay, let's start with that one. Director?
Mr. Chairman and Representative Larson, so the money that we currently spend in this area actually doubled this year. It went from about $5 million to $10 million. That's in the program that's called Transportation Alternatives. It's not specifically designated to have to be used for crosswalks, but it's things like bike paths and greenways, and it could be used for crosswalks. And so that is certainly in light with the current administration's priorities for alternate transportation use.
All right,
Mr. Chairman.
Yep, please.
A follow-up on that, I great to hear that you increased the amount. I guess I want to make sure that if we do go with this bill and we do add the 10 million or whatever dollars we do put there, that this is to add to that and not to replace what you already are spending.
Director?
Mr. Chairman, Representative Larson, yeah, absolutely. The 10 million that we're currently spending is federal. It does require a match from local communities. And so we would see this state money that would be added on to that and would certainly basically double that money. Although I do see that this extra money, if it passes, would have a narrower niche in use than the greater transportation alternatives.
Okay. Is that good, Representative Larson? All right, thank you. Any additional questions for YDOT? Okay, thank you, Director, and
Thank you.
Mr. Fulton. Do we have any public testimony online? I don't have anything on my list. Okay. In the room, wishing to testify on this bill, please come forward. Welcome again.
Thank you for having me again. For the record, I'm Janelle Jones. My son, I believe, was the beginning of all of this bill, so I really want to thank you all for considering and moving forward. If we do that on behalf of myself, but also on behalf of all of the children in the community and those who would benefit from it. This morning, I would like to propose an idea that I believe would be a very proactive approach to some of the safety issues concerning the crosswalks and in school zones, such as speeding through and driving over occupied crosswalks. I have researched a little and have talked to a few people regarding cameras that issue citations. I know other states use them. They've been around for a while, but as technology has improved, these have been very effective. I see the issue first at hand. Myself being on the crosswalk at McCormick Junior High, I am there no less than 5 shifts a week. Sometimes I do 6. And I see speeding on a daily basis in the clearly marked 20-mile-per-hour zone. I have had drivers drive right over in front of me while I have teenagers right behind me while I'm in the middle of a crosswalk holding up a sign. They are not paying attention, it's obvious. I'd like to note for the record that here in Laramie County, we have 36 schools in Laramie County School District. 34 of those are within our city limits. That does not include the private schools. We do currently have only 4 traffic patrol officers that are out. So that is kind of stretching them rather thin. I know that here in Laramie County, we are the lowest as far as traffic enforcement goes, and our city is only growing. So I am asking you to consider the use of these automated speed enforcement cameras in the busier high-traffic school zones. For example, we have clusters of where all of our junior highs and high schools are. They're all kind of clustered together, and those tend to be on busier roads. We also have the issue of, obviously, teen drivers, the more inexperienced, passing through other school zones where you've got junior high school students, and sometimes elementary kids walking home during that time. The other streets would be something similar to, these are just examples, but like Davis Elementary on Yellowstone. Out there on Del Range, I had the pleasure of being out there watching on Del Range near Dildine Elementary School, where it was clearly marked 20 miles an hour, and there were drivers that were, if I had to guess, going at least 50 to 60 miles per hour. They were going highway miles. We've got Baggs Elementary School on Pershing. So these are just a couple of examples, and they don't need to operate 24 hours a day and 7 days a week. My request would just be when the 20-mile-an-hour lights are flashing. And to make it also a full disclosure, so we could put up a sign on those 20-mile-an-hour signs that does indicate that there are cameras in use. I feel strongly that correcting driver behaviors and habits would be key to making our routes to school safer. One of 2 things happen when a driver is cited. They are forced to either slow down in the future and drive more aware, being sure not to run red lights and following the speed limits in those areas, or they're going to take a different route. Me personally, I wouldn't care what they did, as long as we were able to bring order and safe and aware driving in our school zones, and to create it also would create a zero tolerance policy for speeding and driving over occupied crosswalks. I'm just asking that that this is not to do instead of using our traffic enforcement officers, because we so appreciate them and we need them. And there are some things that the cameras will not pick up on that we need them to be able to cite drivers for. But this is just to support our law enforcement and to make their job a little less grueling when we have so many schools and just four officers currently here in this city. I'm not really sure, and I haven't looked into it, what it is like in the other counties, but I'm just using this one for an example for a busier community. Another benefit that I've researched is the increase of revenue that these cameras would provide. The majority of these companies do not charge anything to install them. They only require a percentage of based off of the citations that are issued. And I do realize that there is a percentage that would need to go to admin, like within the city, somebody to be able to mail out these citations to individuals. But I personally think that an idea would be to take the remainder of that revenue that is created and put it back into the Wyoming Safe Route to School program to continue to upgrade our crosswalks and school zones. And I believe that this is a proactive and not a reactive solution to the safety. Bridges and overpasses are a great idea, but it is not conducive in a lot of areas. Like, for instance, the crosswalk that my son was hit on. That is right next to a neighborhood. There is no place to put an overpass or even an underpass right there without moving houses out of the way. So I'm just trying to think kind of outside of the box of things that we've already tried or we have thought about, but maybe just a new solution for that problem. I do believe that these cameras could save lives, and the benefit of generating revenue in our city in our state all together cumulatively, I think would be an alternative solution for speed enforcement.
Mr. Co-Chair, thank you, Ms. Jones. Great to have you back. And
Thank
your
you.
commitment to provide solutions to this very important issue. Committee members, to your knowledge, Ms. Jones is aware that this cannot be a committee bill, her idea, and is providing this information both to the public and the stakeholders in the room with the understanding that it would be an individually sponsored idea if taken up by any of you or any other legislators in this next session. Also, I think important to note this concept would not be new for Wyoming. In 2019, Senator Ellis sponsored the school bus safety bill, which was the first time that Wyoming considered the usage of cameras as a means to issue citations associated with this same topic. And so there was some resistance at the time to that because, as we've all visited other states, and they can just issue a citation without necessarily knowledge of who's driving the vehicle and other pieces. We did cross that bridge in 2019, not a pedestrian bridge, but the idea of issuing some type of a citation, whether it be criminal or civil in nature, associated with these violations. So that was Senate File 80 in 2019, just as a piece of information. Thank you, Ms. Jones.
Representative Yin?
Mr. Chairman, thank you. So we actually had Senate File 3 last year, which was enabling legislation for automated vehicle identification systems. It passed through the Senate. It failed in House Transportation, but I would love to get Director Reiner to give us an overview of what that looked like and whether that is something, a similar legislation that Ms. Jones is looking for to try again this time around. And it did pass through the Senate 1911, I believe, is what the vote was there, but just failed in House Transportation.
Thank you, Representative Yin. Any questions for Ms. Jones? Ms. Jones, of course, we very much value your testimony and enjoy you joining us. And did you want to make some comments as well?
Thank you, Chairman Olson. My name is Ann Clement. I'm here on behalf of the Cheyenne Mayor's Council for People with Disabilities. I also happen to be a mother of three. I have a student at Miller Elementary here in Cheyenne, at McCormick, and at Central. I'd like to speak to the department's testimony as to the reference of the statute and the crosswalks. I know that they had brought up an incident that happened on Central. I do believe that was in reference to a student that was hit. There was a student from Miller that was hit within the last 2 months coming across Central. So the idea of those crosswalk needs being just adjacent to schools, while that is certainly a highlighted area, there are more streets than just those adjacent that are the safe passage to school that the department referenced. That would be a really important part to include in this legislation as it moves forward. As a representative of the Mayor's Council for the People with Disabilities, this of course would include anyone of any age with a disability that would have a safer passage, whether it be to school or to another part of their community, that we've identified as a priority for the council this year. So we would sincerely appreciate consideration for that direction as well. So I've been speaking with Ms. Jones about her idea about the cameras, and we're certainly supportive of that also. I'm happy to work with the committee in any fashion to move this legislation forward. So thank you.
Thank you, Ms. Clement. Questions, committee? Co-Chairman Nethercott?
Thank you, Mr. Co-Chairman. Just, that brings up an interesting point. And I think we've discussed this before, but I'm just curious if anyone knows in the room, stakeholders, Director Reiner, how many minors in the state of Wyoming have been hit or struck by a vehicle within the last 2 years? Because it feels anecdotally it's a lot, or a surprising number, but, and I know that we received some testimony on that before, is that right, committee? I believe YDOT might have provided us a presentation with that information in it. But it is surprising as a Cheyenne resident, it seems like that more often than not, we are hearing some type of news coverage of a child being struck on the way to school. Unfortunately, some are killed and some are survive.
Yeah, Mr. Chairman, Madam Co-Chairman, the statistics that we have are for 2021, for the last year. And what we know there is that we had a total of 14 pedestrians hit underneath the age of 14. And it actually is a bell curve. And so there's also 14 people hit between the ages of 55 and 64. And so it sort of looks like a bell. I was trying to quickly add up the total numbers that were hit, but we had 12 actually fatal accidents in 21 of pedestrians. Now that's defined as not necessarily people, it could be on skateboards or roller skates, but just really not in a vehicle. And so 12 out of a total of about 96 is our total fatalities on the system last year. And so that's a high percentage. The other stats that we know is that about 88% of the fatal injuries were in urban areas, and about 12 then were in rural. 27% of the fatalities were in intersection crosswalks. So that's 27 in crosswalks, and about 37% were in an intersection with no crosswalk. And then the rest, obviously were somewhere else. And then about 65% occurred in daylight. A lot of times you think, these are occurring at night. And really, statistically, most of them are during the day.
Chairman.
Thank you. And then just to follow up, and this might be a question for Mr. Fulton. Traffic engineers certainly focus on this as part of their professional occupations and study of what type of traffic mechanisms have the highest return, such as what really does reduce pedestrian vehicle interactions, particularly in school zones, what types of tools are most effective, and do we know that information? Is there some data in the traffic engineer's toolbox that would indicate what that is?
Mr. Fulton.
Is it the blinking sign? Does that really slow the traffic down? Is it these kind of deterrent measures with punitive sanctions associated with hitting them in the pocketbook, of getting a citation? Do we know some of, I think they all are necessary, but do we know what is the greatest effectiveness?
You know, by the, Madam Chairman, probably the best thing is to avoid the conflict altogether if you can. That would be the under processing or over processings to get them away.
This is my guy.
But yes, you know, we will look at, you know, the amount of traffic, the type of traffic, speeds, and then look at what's the best way to protect those. That can be anything from, like you said, signs to crossing, dedicated crossings, things like that.
Thank you.
Thank you, Mr. Fulton. Committee, any additional questions? All right. Do we have additional public testimony? Any additional public testimony? Okay, seeing none, I will close public comment on 23 LSO 0283. Committee, what is your pleasure? Moved by Senator Cooper and seconded by Senator Cost. I think the senators moved the last bill too, so reps. I know we're getting close to lunch, but you know, we're doing good work here. Need a coffee break?
Mr. Co-Chairman, I would move the amendment as proposed by YDOT.
Okay. Been moved and seconded by Senator Cost.
And I would, to address, let's just move it.
Okay, it has already been seconded. You don't want to make any changes to it?
I think it'd be easier
To pass it?
to pass it and then amend the amendment.
All right. Any discussion on the amendment? Well,
That's what we'll do next.
that's what we'll do next. We'll just pass the amendment as is, and then we'll work through it. Representative Grego.
Mr. Chairman, just so I'm clear, we're passing the entire proposed amendment.
Pages
the
1
entire
and 2.
sheet.
Correct. That's my motion.
As proposed, YDOT proposed amendments.
And I anticipate making further amendments, and we can do those now, just because everyone feels more comfortable doing that, evidently. So,
Okay.
as discussed by Representative Washut and our concerns, as we recall on page 2,
Yep.
in the red language there is provided in the YDOT amendment, the director indicated to change that word "and" to an "or." Representative Washut had concerns about that, if we recall from the discussion, that there'd be some type of limiting factor there. And so Director Reiner provided some alternative option language that we can certainly continue to think about and massage, but it was after the word "local transportation plan," to then strike the rest of that red language and replace with "that supports safe routes to school."
Next.
Mr. Co-Chairman, you know, I think YDOT spends too much time providing reports. And I don't necessarily, and this is YDOT's, because they're used to providing reports, they've just been trained to do so, and they automatically report. But I do think their familiarity with the legislature and them being routinely in front of the Transportation Committee, that this just adds one more, I think, bureaucratic regulation on them that may not be necessary. I know we'll keep track of it. So I would actually propose to strike the proposed amendment, the reporting requirement.
I think that's also in line with a newer philosophy that the legislature has adopted to try to funnel reports through singular legislation as opposed to bills as we go along. So I think that's appropriate.
Yeah, so that would be my proposed amendments to the amendment, and that's therefore my amendment.
Okay. Thus, we have an amendment. And a second,
not
it's
double
been
your
seconded twice now. Good job, committee.
Question.
Okay. Question on the amendment, all those in favor signify by, whoa.
Can we talk about the amendment for a minute?
Okay, we certainly can. Senator
Okay.
Cooper, please.
Because I have some questions on the amendments to the amendment.
Okay.
In page 3, planning, design, and construction, I think that's something we need to consider. YDOT has the staff in place, and they're already doing planning, design on quite a bit of infrastructure. It can easily burn up our entire $10 million in planning and design. On page 4, line 6, the striking of the time requirements, I think that that releases YDOT of any accountability to do this work in some kind of a timely fashion. I think that leaves it open-ended, and I don't think that's appropriate. Thank you.
Any further discussion on this? Representative Rodriguez-Williams?
Thank you, Mr. Chairman. I agree with Senator Cooper on page 3 in regards to planning and designing. I would hate to see a lot of this funding go towards hiring new personnel when there's existing personnel and several prioritized projects already that are already in this planning and designing phase already.
Co-chairman, just one question. Question on the amendment. Ready? All those in favor signify by saying aye.
Aye.
All those opposed? Okay,
So now, Mr. Co-Chairman,
that
if I
amendment
may.
has passed.
Yeah, thanks. Just to direct the committee, now, if you want to address your concern about that topic, I would then make a motion, if I were you, which I will not support, but I will make a motion to strike that now, and that'll help clean it up, as opposed to all of us dealing with 12 different subjects within one motion. So that would be my suggestion to those that have concerns about that particular piece.
Okay, is there an amendment? Senator Cooper?
Thank you, Mr. Chairman. The first one I'd like to address then is the amendment with planning and design. I'd like to strike the planning and design language from both lines A and B.
That's seconded by Representative Rodriguez-Williams. Discussion.
Representative Yin?
Mr. Chairman, thank you. So if there is no plan or design currently ready for something like the school in Cheyenne, they essentially wouldn't be eligible for any of the funding until they spent money themselves on hiring someone to plan and make it to plan and design. Is that the case with this amendment?
Mr. Co-Chairman, if I might add to the discussion, I think the concerns that I've heard is distrust from some of the committee members regarding YDOT's usage of these funds, and that knowing how much engineering costs are in the planning and construction phases of large construction projects can consume a great deal of money and time, that it would essentially require all of the funds to be utilized for the purpose of planning and design. I think in fairness to the department, this is a very specific usage of, certainly YDOT has plans of highway construction all across the state at all times. But this is a very specific thing associated with the installation of pedestrian overpasses. And I would dare submit that they have no plans or designs associated with the construction or implementation of any pedestrian overpasses for any school zone. Is that a fair statement? And so in order to do that safely, they have to do planning and design associated with the unique structure of a pedestrian overpass or underpass. And that is different than a road and is unique to each particular area. And it may be that it costs too much money. However, YDOT did not express that concern. They did not ask for more money. And maybe we all think that they'll come back next year with a request for $50 million, but that's not what's happening today. And I don't anticipate that happening now, and you can certainly vote no at that time. But that would be my thoughts on that particular piece.
Representative Craigo?
Thank you, Mr. Chairman. And I guess to pile on a little bit to what the co-chairman just said, I think some of the planning and design will happen by entities that are not the Department of Transportation. Some of these improvements are going to happen on city, a lot of them, I would assume most of them are going to happen on city streets, county roads, and the department may not necessarily be involved with that planning or design, and our local government entities will need that additional funding to be able to complete that planning and design. And so I would, I guess, speak against the amendment at this point.
Okay, Senator Cost.
Thank you, Mr. Chairman. The other concern I'd have is, excuse me, these are in so many different places with so many different circumstances that I don't know how any one set of plans or two set of plans would ever necessarily hold. There's some that are on state highways, some that are on county highways, some that are in the cities. I really think that you got to have some kind of a plan to start with it. I would really struggle to say no plan, just get it going, because that doesn't necessarily make sense in this day and age, in my opinion.
Senator Cooper.
Thank you, Mr. Chairman. My amendment did just exactly what I intended for it to do, was spark some discussion on this. Obviously, we have to have planning and design for any type of project. But when we go into something like a school crossing or an overpass, that planning and design can easily run into $10 million just for one project. And we have such a small amount of money to work with here. So how do we, as a group, control that with the help of the department to ensure that we get the maximum return on our investment here? I'm really confused about how we go about really getting our bang for the buck.
Okay. Additional discussion on this amendment? All those in favor signify by saying aye. Aye. All those opposed? That amendment has failed. Additional amendments or discussion? Yes, Senator Cooper.
I'd like to propose that we put a date for completion in this, back on lines 4 through 6. The original strike through was completely through the time limits on it. I think 2024 is a little bit too tight, but I would like to see some kind of accountability on making sure we get our money spent in a timely fashion. And I'd like to propose that strikeout be reinstated with a date of July 1st, 2026.
Senator Cooper, you're just working off of the amendment?
Of the amendments, because that's what we're fixing.
Mr. Chairman.
Mr. Fuller.
So
please.
Senator Cooper, on page 4, line 10 of the bill, there is language that states that the projects must be completed by 2028.
June 30th, 2028. Is that sufficient?
Then I'm confused. What are we striking out the language in the amendment?
The reporting requirement
That's
to
the report.
Transportation Committee.
That's just a report.
Okay.
Are you good with June 30th, 2028?
No, sir, I think that's too far out. I suggest we move that back to 2026.
Okay. So there's an amendment to change line 11, June 30th to 2026, seconded by Representative Craigo. Is that a second? Because you want to discuss it.
Yes,
Please.
Mr. Chairman.
Been seconded.
I guess I was just going to point out for clarification purposes, the amendment applies to lines 6 through 8 on page 4, which is different than expending and or distributing. Line 10 and 11 is when the money has to be actually spent or there's a reversion back to the state.
Okay, it's not the date, it's not the date that a report is due. I see, I'm tracking you now. Representative Oakley?
Thank you, Mr. Chair. I was going to make the same point. So we did strike out, they're two very different dates.
Yes.
The one that we struck out was when the department shall have the funds expended. The one we left in is when projects need to be completed.
Okay.
So for that discussion. I mean, I tend to support what Senator Cooper's going with, which is not, we took out the department expending the funds and just provided for a report, which we've discussed.
Mr. Co-Chairman?
Yes.
This is a really good concern. What remains in the bill is that the projects have to be completed by June 30th of 2028. All other precondition requirements, there's no statutory deadline, so we're not micromanaging these projects. So we're not requiring YDOT to expend the funds to the cities, counties, and towns, or however that might be, prematurely or too late. Maybe they need to be, I mean, who knows? So that they have the flexibility for the utilization of those resources. However, the project will be complete by June 30th, 2028. Can we let go of the control? No.
Senator Cooper and then Representative Provenza? No. Senator Cooper.
I'd like to rescind the amendment, please.
Okay. The amendment has been rescinded. Are there any additional amendments? Or discussion? Question? Okay. We'll do a roll call with Emily on 23 LSO 0283.
Senator Cooper,
Aye.
Senator French,
Aye.
Senator Kolb excused, Senator Cost,
Aye.
Representative Crago,
Aye.
Representative Larson,
Aye.
Representative Oakley,
Aye.
Representative Provenza. Aye. Representative Rodriguez-Williams,
Aye.
Representative Washut,
Aye.
Representative Yin,
Aye.
Representative Zwanitzer.
Aye.
Co-Chairman Nethercott.
Aye.
Chairman Olson.
Aye.
That passes.
All right. Now, committee, here are my thoughts, and just tell me if you don't like them. But we have one topic left. It's scheduled for 1:30. Where we'll be looking at two draft bills, the clerks and a district court bond amount and a probate filing fee. I see the clerks are here. If all the players are here to move forward, my proposal would be maybe we take a brief break and then we come back and we finish our agenda and we adjourn instead of going to lunch and coming back. Does everyone feel comfortable with that idea? I think we could reasonably be done by 1:30. Okay? All right. Then let's go ahead and just take a 15-minute break and we'll be back. Thanks, Mr. Fuller, Emily.
Because we can.
Yep. Yeah, and it's the whole Wyoming GOP doing it.
Oh, it's her. It's just,
It is.
I'll tell you what. Yep. I have better words for him, but I'll just try not to say it. Just, but I just, you know, okay, I wanted to get the run before term in the hospital. Ran for it. They were trying to make sure that people knew that they shouldn't.
It should be it's a nonpartisan job. It's like a school board. They were telling people in Warren who they need to vote for.
They were sending out ballots was showing you exactly who to write for, who to write in, who to.
Yeah.
And unfortunately, right there, very much behind it too. Because she was right in the middle. So was Dan. Dan puts out a thing and said, you want conservative for your school board. Here's the kids, the teacher, the people you better. Good.
All right, committee, we are back. Your Judiciary Committee, Joint Judiciary Committee returning for its final hour and a half here, maybe. Judicial branch topics. We have Bill Draft 23 LSO 0002, probate filing fee amendments. Who will be introducing this bill?
Yeah,
Mr.
I will,
Fuller?
Mr. Chairman, and given the brevity of this bill, just do it from here if that's all right. I won't steal much of the
You don't want
work.
to stretch your legs?
I'm good, Mr. Chairman.
Okay, all right.
You know, I won't speak for the working group, but after the committee reviewed this bill in September, the committee directed a working group of Representative Washut, State Court Administrator Butler, and the clerks of district court to review the bill and recommend changes. The draft before you is the product of that working group. This bill would increase the district court filing fee to $160, which would match the total amount that is paid currently when one files a case in probate court. So that's the change on page 2, lines 5 and 6. The staff comment just provides the full text of the probate fee in 22401, and then the district court fee. With that, Mr. Chairman, I'll stand for questions.
Questions for Mr. Fuller? All right, very good. Let's bring up we had a working group on this, but that was our clerks. So let's bring up our clerks and our judicial branch as well. Welcome, Ms. Butler.
Thank you, Mr. Chair. My name is Elisa Butler. I am the State Court Administrator for the Wyoming Judicial Branch. I think Mr. Fuller did a very fine job of introducing the bill. We did have a working group. We met with some clerks of district court, Representative Washut and I met to discuss this bill, and this is the product of that discussion. Just to give you a little bit of background of why we are talking about this bill. Currently, as the filing fee sits, there are 2 different filing fees for whether or not you file a probate. So a probate filing fee is different than a civil filing fee. Both of those cases are heard, kinds of cases are heard in district court. So it creates some potential for confusion. It also creates the potential for some unfairness. And to explain that, in some of our counties, based on some advice from county attorneys, the district court clerks are charging different fees for guardianship and conservatorship cases. So in some counties, they are charging the probate filing fee. In some counties, they are charging the civil filing fee. And currently, as it stands, those are 2 different fees. So we would like to make those 2 fees the same in order to limit the confusion and also to just create a standard across the state on how fees will be charged or assessed when a case is filed. So that is just a little bit of background there, and if you have any questions, I'd be happy to try to answer them.
Committee questions for Ms. Butler? No? Okay. Clerks, you're up. Do you have anything to add from the working group?
Mr. Chairman,
Oh, Clerk Wood, welcome.
thank you. I apologize that I'm not there today, but the weather up here in Northeast Wyoming's got snow and I have a family commitment tomorrow. So yes, the association would like to make I'm hoping a brief statement. Our objective is to amend the current draft to gain consistency and fairness for the district court filing fees. This amendment will align our fees, making our jobs as clerks much easier. It will resolve the issue of fairness regarding the guardianship and conservatorship filing fees. By aligning these, we hope to eliminate the confusion with the public, the attorneys, and the clerks, and eliminating confusion with additional steps for the clerks when opening new cases within our new case management system, as it is configured to assign the same filing fee amount for both probate and civil fees. And it hopes to help ensure the smoother transition to our e-filing system, which is being rolled out as we currently speak. The Wyoming probate filing fees have only increased $156 in 130 years. The civil filing fees have only increased $115 in the same amount of time. When comparing our filing fees to surrounding states, we found that the domestic relation filing fees are an average of 83% less than Wyoming's, or Wyoming's is 83% less than the surrounding states. And other civil filing fees in other case types, we are 115% behind the surrounding states. By increasing the civil filing fees, the amount to match the probate fees will generate a modest increase of only $40 per case, and which is put back into the county general funds. As we stated before, the filing fees don't generate funds to support the Clerk of District Court's budget. We put together a small, medium, and large court for fiscal year 21-22. Platte County, they collected $12,400 of 5%, which would be 5% of a $242,500 budget. Teton County collected $20,040 in filing fees, and is 1% of her $6,665.30 budget, sorry. And Campbell County's, they collected $71,715, which is 4% of her $1,563 budget. We would stand for any questions if you have any.
Thank you, Ms. Wood. Do we have any questions for Clerk Wood? Okay. Do either of you have anything to add? No? Okay. Representative Washit?
Thank you, Mr. Chairman. It was a pleasure to be on the working group and to have an opportunity to spend some time talking more in depth with the clerks and with Ms. Butler as we parsed out this issue. And just for the benefit of the committee, when you think about the total cost of filing a civil lawsuit in the state of Wyoming today, the filing fee is such a minor component of that cost, you know. And when you look at the long term, the testimony we just heard from Clerk Wood about how much our filing fees have increased over 130 years, and how we are situated relative to the other states. When I came away from that working group, I had much more confidence that this bill draft was appropriate than I had before we met. And so I would encourage the committee to support the bill draft.
Committee, any questions for Vice Chairman Washit? Should have made you walk all the way around and go over there. I was slacking. It was Mr. Fuller who put me in that habit. All right. Any questions for the working group at all? No? You're just eager to get to the bill.
Public comment?
Oh. No? Okay. No public comment? No public comment in the virtual world? I'm really trying here. Okay.
I'm standing silent.
All right. We are closing public comment. Committee, what is your pleasure? It's moved by Representative Zwanitzer, seconded by Representative Craigo. See, now I'm going to give the representatives a chance to redeem themselves now. Discussion on this bill? Discussion on this bill. Discussion in the virtual world. Amendments on this bill. Question on the bill. Emily, will you please do a roll call vote on 23 LSO 0002?
Senator Cooper? Senator French?
No.
Senator Kolb excused. Senator Cost? Representative Craigo?
Aye.
Representative Larson?
No.
Representative Oakley?
Aye.
Representative Provenza?
Aye.
Representative Washit?
Aye.
Representative Rodriguez Williams?
No.
Representative Yin?
Aye.
Representative Zwanitzer?
Aye.
Co-Chairman Nethercott?
Aye.
Chairman Olson?
Aye.
That passes.
All right. Good job, committee. Yeah, please go, Chairman Nethercott.
Thank you, Mr. Co-Chairman. On this topic, so you heard some very compelling testimony concerning how Wyoming's filing fees in the courts are so low. But we are not changing the amounts for those filing fees in any substantial way. And so we have identified a problem, but I'm not sure that we have provided a solution to it. We did provide equity within the filing fee associated with the civil fee and a probate fee, so the county attorneys are no longer confused. And that was a passive-aggressive hit. But I do anticipate, in light of this very compelling concern that in over 100 years, we haven't had any of these fee increases. I would say that Co-Chairman Olson and I have voted on every single one in the last 100 years. And so Judiciary Committee members of the legislature moving forward, I anticipate that in the coming years, you might need to raise this in a significant way to have a meaningful impact on what that fee's purpose actually is. But for now, we'll just make it all the same.
All right. Consistency. One down. Next, we have draft bill 23 LSO 0092. Mr. Fuller?
Yep.
Is this one brief as well?
Very brief, Mr. Chairman, and
You still don't need to stretch your legs?
still don't need to stretch my legs.
All right, okay.
Thanks, Mr. Chairman. So 23 also 92, draft 0.3, this is 6-02 in the meeting materials. This is a bill the committee looked at in September and requested after the May meeting, after hearing discussion regarding the protection of public funds and clerks of district court. All this bill does is amends 53208, so the bottom of page 1, top of page 2, it amends the bond amount for clerks of district court from $10,000 to $100,000. The staff comment on page 2 and then the entirety of page 3 just lists the bond amounts required for other county officers. And with that, Mr. Chairman, I'll stand for questions.
Committee, questions for LSO? All right, thank you, Mr. Fuller. That was brief. Ms. Butler, clerk on our Clerks Association, do you have comments on this bill? Nope. Okay. How about the commissioners?
Good afternoon, Mr. Chairman, members of the committee. I'm Jeremiah Riemann here on behalf of the Wyoming County Commissioners Association. At your September meeting, you requested some additional information regarding bond amounts, as well as the potential cost of increasing the bonds, and we've certainly tried to collect that information. Mr. Chairman, I did hand out a document with various bond amounts and a chart there. I'll just briefly go over that. We've not heard from all counties, but have heard from a sufficient number of them. Give the clerks credit, they've been preoccupied, so the distraction of my request was not their priority, and nor should it have been. As noted at the top of that chart, we've just mentioned the minimum bond amounts that exist for each one of those county elected positions. I do want to point out a couple of things that may not be very apparent to a lot of people, but there are 3 positions that require at least 2 sureties. Those are the clerks of court, and the assessors. The treasurers are an odd little beast. There's no actual amount that's set. It's left to the discretion of the county commissioners, or they have to secure at least 3 sureties for that position. As you can see from the data, the amounts that are set by commissioners in each of these instances do vary across the state. All of them are at least meeting the minimum. Some of them go up quite substantially. You'll see at least one of them goes up to at least or up to $5 million. We did confirm that is correct. The Uintah County Treasurer has a bond set at $5 million. So that's the bond information that I wanted to be able to provide to you. Now, what's the cost of these bonds? We asked a couple of counties to evaluate this. We were hoping to get a little bit more data. Again, we've not been able to do that. I certainly hope to have it to you by the time that this might get to the session. What I know is that in Converse County, for commissioners, clerks, assessors, coroners, and clerks of court, the 4-year term bond amount is $325. They have a 4-year term bond amount for their treasurer at $1,275. The difference being that, as you can see for Converse County, most of their bonds are set at $5,000. For their treasurer, it's set at $75,000. So there is a jump, but not a crazy amount considering all things. We did also get some data from Carbon County, and for all of their positions but the treasurer, their term amount is $340. And it doesn't matter whether it's a $1,000 bond or a $5,000 bond, it's $340. Their treasurer has a bond at $100,000, and that cost is $850. All that said, and all things considered, I don't think our association would oppose this legislation moving that bond amount from $10,000 up to $100,000. If you'll indulge me, I do have a couple of other things to perhaps work through. The legislation is focused on the clerks of court, but certainly has the staff note relative to those other positions. I've provided you a draft amendment because I think it's our belief, after we've gone through all of this information and talking to the counties, the commissioners, the clerks, and others about this issue, that we really need to do away with that 2 surety issue. What we found is that many counties, perhaps the bulk of the counties, don't even know that there's this requirement that they're supposed to have 2 sureties. So we have that to deal with. As you can see on the spreadsheet, at least Crook County knows that they have to have it for their clerk, but we have not heard that they have it for those other positions where they're required to have 2 sureties. We also heard from Carbon County that the bond companies that they work with don't have a mechanism to set 2 sureties within their system. So what that forces them to do is then go out to 2 different companies in order to get their sureties, and that didn't make a whole lot of sense to them. What did make sense to all of us is that you just simply increase the bond amount. So the amendment is intended to take out the 2 surety language that's currently in state statute. The first 2 pieces of that proposed amendment on page 2 deal with the clerk of court. The others assume that you would bring in the other positions. Certainly your decision on whether you wanted to do that, but we wanted to be able to provide that information. Quite frankly, as I looked at it, it might just require some cleanup throughout the surety language, because it talks about surety, sureties, and lots of other, it's not consistent amongst them. But nonetheless, we tried to just take out the 2 surety piece with that proposed amendment. Mr. Chairman, if you'll just indulge me on one other thing that I did bring up at that September meeting, and that was the issue of liability overall. In Goshen County, I mentioned that they had separate liability insurance, and because of issues of who has authority to actually audit those records, their liability insurance did not cover them. So that leaves me questioning, even if you had a bond increased, do you really solve the issue? And I mentioned at that time that I had heard from the Department of Audit that they were aware of some federal statutes that had language in it to try and provide some clarity. We followed up with the Department of Audit and found that that language that they were referencing to me is contained in the Children's Free and Reduced Lunch Program, which is intended to give states and the federal government the liability clearance to actually audit those programs. Admittedly, I tried to draft some language for your consideration, and as I dug into that, I thought, this is an issue that's probably best left to your attorneys to try and help me even figure out where you would put that in statute. So I don't come to you with an amendment relative to that issue, but I would ask that if one or more of you might be willing to sit down and work with me and work with LSO, that we try and find the proper language to insert into statute to ensure that regardless of what happens moving forward with these records in particular, we don't end up in a situation where a county has a bond, may have separate liability insurance, but again is left holding the bag because nobody wants to pay on that bond because the county was deemed to be in the wrong. So with that, Mr. Chairman, I'd stand for any questions and appreciate your consideration of all this.
Committee, Co-Chairman Nethercott.
Thank you, Mr. Co-Chair. Mr. Freeman, thank you again for getting this information and digging like you have. To me, this seems like an issue that does need to be addressed. There's nothing necessarily urgent to it, but there is a gap, I think, that leaves Wyoming counties vulnerable. And I know they won't state that because there's a position that they do everything just fine and don't meddle with how they do it. And I get it. But I do think that there needs to be consistency across the state for all of the counties with same or similar requirements that then allow for appropriate statutory requirements allowing for that bond to be utilized in the event something that happens again, right? I mean, we learned from that lesson that as a result of the failure to have proper requirements in place, that the protections weren't available. And so I do think that it is the legislature's role to eliminate the risk to the people of Wyoming and our counties, which we love, to provide that statutory guidance. We obviously can't do that here, But Mr. Reman, what I'm asking and getting at is whether or not you would provide this as an interim topic to a committee, this or others, I'm not sure which is the best committee, but on this topic, certainly not overly exciting, but important, and needs to get done and done correctly. So that would be my question to you, if you will do that, and then committee members be a sponsor for Mr. Reman in the event that interim topic moves forward.
Mr. Reman?
Mr. Chairman, Madam Co-Chair, I'm not opposed to bringing this forward as an interim topic. It is a critical thing for us to try and work through, and so I do see the urgency in doing that. I'd love to try and address it this session if possible, but absent that, I'm not opposed to that.
Mr. Co-Chairman, follow-up. Mr. Reman, you'd like to address it this session. Do you think it's simple enough to do?
Mr. Chairman.
We have so many new members, as you know.
Madam Co-Chair, you're absolutely right. And again, I never want to put you or your staff in a difficult position heading into a session on something that could be complicated. Again, as I mentioned, I tried to do it taking federal statute and then working it into ours, and it was more complicated than I could have imagined. So an interim is certainly fine, but we do need to ensure that there are adequate protections in the short term. And one of those ways is to increase the bonds.
Vice Chairman Washut.
Thank you, Mr. Chairman. Mr. Reman, if you know the history of the two sureties requirement, why was that deemed to be appropriate, necessary at some time in the past? And what's the practical ramifications of having it and getting rid of it?
Mr. Reman.
Mr. Chairman, Representative Washut, I tried to go back and determine how long has this two surety requirement. I didn't get that work completed, but it appeared to be in the similar vein as when these bond amounts were actually set, which goes back to the 1800s. There were some changes in the early 1900s, but it appears to be a very old vestige of our state law. And to the broader part of your question, as I mentioned, most counties don't even know that they have this requirement across these three positions. In particular, Carbon County related to us that they have tried to adhere to it, at least for the assessors and the clerks, and their bond companies really are having difficulty within their systems to even set two sureties with the bond. So it was really forcing them to go out and find a second bond company in order to ensure that there were two sureties. As well, if you look at the language, if you're thinking about sureties, sureties are essentially a bond. So you're forcing two bonds here, and does that make sense, or does it just make sense to set one bond?
Co-Chairman Nethercutt.
Thanks, Mr. Co-Chairman. I think my first instinct here is that bonds are the way to go. But would something completely different be merited here as well, similar to LGLP, right? I mean, in concept, similar, where you're not relying necessarily on traditional insurers or bond companies, and then allows for collective pooling of resources and coverage because the standards are the same.
Mr. Chairman, Madam Co-Chair, I think I'm tracking where you're headed with this, and maybe that does require the interim study that you're suggesting. As I mentioned, the treasurers, it's either the county establishes what that bond amount is going to be, or you got to go find three sureties to set that. So I do think that there are multiple concepts that we could pursue here, whether that's bond amounts, looking at something through an LGLP program or another optional program that the counties could utilize. I think all of them are worth consideration.
Committee, additional questions for Mr. Inman? How about in the virtual world? The virtual world's tailoring off. Okay, thanks for your testimony. Do we have Miss Rhodes in the virtual world? She had signed up. Paige Rhodes, Johnson County Clerk. No? Okay.
I think that was on the previous bill.
You're right. It is. Okay. Any public comment, additional public comment? Last chance to make us work a little bit longer today. Closing public comment. Okay. Committee, what is your pleasure with 22 LSO 0092?
Move the bill.
Moved by Co-Chairman Nethercott, seconded by Senator Cost. House, you were doing so well, and then you ate lunch. I blame lunch.
Mr. Co-Chairman, I would move the amendment as proposed by the County Commissioners Association in total.
Okay, it's been moved and seconded by Vice Chairman Washit. Discussion on the amendment. All those in favor of the amendment signify by saying aye. Aye. Any opposed? That amendment's been adopted. Back on the bill. Further amendments to this bill? Robust discussion on this bill? Oh, Vice Chairman Washit.
Thank you, Mr. Chairman. Just a comment, and I've only been in the legislature for 4 years now, but it's not uncommon that we hear about agencies or governmental entities that are not in compliance with existing statute for a variety of reasons. And I just wanted to mention that didn't escape me, this idea that we have statutes that require certain things that across the counties and across the agencies, we don't always comply with. And so I just think it's something that we need to pay attention to as a committee, that we pass requirements and then, or previous legislatures have passed requirements that are just ignored. And I find that problematic.
Co-Chairman Nethercott.
Thanks, Mr. Co-Chair. I think Representative Washit makes a valid point that this committee, I think, has certainly seen that, if we recall, with like juvenile justice reporting, that never occurred for decades. This particular issue, and no doubt there's many others. And so, one idea about that is to provide a mechanism, and I think the hesitation is for those agencies that know they have the statutory requirement, but it doesn't work, like the juvenile justice reporting, right? For whatever reason, it had its challenges, and they chose to say nothing, or maybe they did. But there was no effort to get that amended or get it addressed. And so there was kind of this willingness to not follow the law, or acquiescence, right? Complacency for not following through with the law. And so how do we build more trust with those that are required to follow the law to approach with changes and to say it's safe to do so? Hey, we're not doing this, and here's why. It doesn't work, because I'm assuming that's the case. It doesn't work. There's a pragmatic reason behind it, or it needs to be modified in some way. And so how do we invite the public to us? Because I think it's harder the other way around, to say, hey, come forward now with these proposed amendments. And a lot of agencies are much more proactive about doing that than others. Department of Corrections being one, it's very proactive. So that would be my kind of commentary to that, is what has been the historical relationship between the legislature and those agencies, and the home committees and those agencies, in order to facilitate corrections for lawful action.
Additional discussion on this bill, committee? Representative Craigo?
Thank you, Mr. Chairman. So I'm struggling a bit with the bill draft and just the logic behind it. We're changing, I mean, the main purpose of the bill draft was to change the bond amount for clerk of district court. But yet we have other county officers who handle exponentially higher amounts of money. For example, our clerk, and we're gonna leave that at 4,000. Or we're changing the district court clerk to 100,000, and the amount of money they really handle is limited. And so I'm just, I'm struggling with that. I'll probably vote for the bill draft today, but I may not when we get to session, unless we're able to fix some of those. And I know the County Commissioners Association, that's one of the things they're talking about. But I really think we need to look at these other, if we're gonna modernize the clerk's bond amount, we should be modernizing everybody's bond amount, not just theirs. I feel like we're picking on them, and I'm not sure why. And so I guess
Goshen County is why.
well, we have other offices that have had the same problem in other counties, and I can think of several right off the top of my head, and I won't, call out those counties, but and it wasn't in the clerk of district court's office. And so anyways, I'm just saying, moving forward, I'd like us to at least look at that when we get to session and fix some of these other amounts as well.
Mr. Co-Chairman, if I can,
Yes.
I think Representative Craigo, of course, is spot on, and the County Commissioners Association has identified that concern, that need. I think the reason why it's narrowly tailored here, right, is because we're the Judiciary Committee and we handle the courts, and we have the district court clerks with us commonly, and that's why it was limited in scope to that, and we didn't have enough information at our last meeting to do anything differently. We do now, thanks to Mr. Riemann, but hopefully, Representative Craigo, you'll have a bill draft.
Representative Yin?
Mr. Chairman, thank you. So Representative Craigo, is your interest in considering this in a separate bill draft? Because I think if we sponsor this bill, the title as it reads now wouldn't allow us to modify those amounts for other positions.
Mr. Chairman, I think to some extent the title will have to change in light of the amendment, to make sure it encompasses the two surety requirement.
So, Mr. Fuller, are you suggesting that we could do a full amendment requiring $100,000 for all county offices?
Well, Mr. Chairman, Chairman Othercott, the bill hasn't been introduced yet, so it's well within the committee's purview to amend as it sees fit.
So moved.
Sorry, it's been moved by Representative Craigo and seconded by Senator Cost. Discussion on this amendment? Okay. Question on the amendment. All those in favor signify by saying aye.
Aye.
And those opposed? Okay, that amendment's been adopted. We have a brand new bill. There was a division? Oh. Okay, any other amendments on this bill? Question being called on the bill? Emily, will you do a roll call vote on 23 LSO 0092?
Senator Cooper, Senator French,
No.
Senator Kolb excused, Senator Cost, Representative Craigo,
Aye.
Representative Larson,
No.
Representative Oakley,
Aye.
Representative Provenza,
Aye.
Representative Rodriguez Williams,
Representative Rodriguez Williams, it's your time to shine, to vote. Would you vote aye or nay?
Muted.
Or you can do a thumbs up or thumbs down. Okay, that's an aye. Thank you.
Representative Washit,
Aye.
Representative Yin,
Aye.
Representative Zwanitzer,
Aye.
Co-Chairman Nethercott,
Aye.
Chairman Olson.
Aye.
Cooper, no aye.
Good job, Senator Cooper.
That passes.
All right. With that committee closing out, just want to remind you that you do have a couple of reports. You have a Wyoming Department of Family Services Juvenile Justice Data Collection System Status Report. You also have a case court report and a judicial council report. Before I close it out, Ms. Butler, did you have any comments on those two judicial reports, or you satisfied if we just review them? Okay, okay. Any burning questions now, committee? Otherwise, please make sure you review those reports. Co-Chairman Nethercott?
Mr. Co-Chairman, thank you. And members of the committee, since we're done so early, but also wanted to open it up to a couple of dignitaries we have in the room. One is Judge Healy is here visiting with us up from Campbell County, originally from, most recently from Cheyenne here, and was a federal prosecutor and now up on the bench in Campbell County. Thanks for joining us today. Judge Healy, yeah. Any questions for Judge Healy, committee? All right, with that.
We also have our director.
Yeah, Director of the Department of Corrections here, Dan Shannon. Thanks for being here with us today. Any communications from you, Department of Corrections? How's it going? Questions for the department?
No? Okay.
And we have Representative Henderson here as well.
Questions for Representative Henderson?
Representative Henderson, come forward, please.
Welcome. Did you have a question for Representative Henderson? No. Oh, okay. All right. Okay, committee. With that, we will be adjourned.
Mr. Chairman, I did want to say, I believe this is Senator Kost's last meeting,
Yes.
and just wanted to express how great it's been working with him over the past 2 years in this committee.
I appreciate it, sir.